Senate will come back to order. I recognize the senator from the 32nd for a motion.
Thank you, Mr. President. I move that House Bill 315 be removed from the table.
Senator has requested that House Bill 315 be removed from the table. Secretary, read the caption.
House Bill 315, a bill to be entitled an act to amend Chapter 24 of Title 33 of the Official Code of Georgia annotated, relating to insurance generally, so as to provide for the Commissioner of Insurance to promulgate rules and regulations regarding cost-sharing requirements for diagnostic and supplemental breast screening examinations. The Committee of the Senate on Insurance and Labor recommends that this bill do pass. Respectfully submitted, Senator Walker of the 20th District Chairman. That completes the order, Mr. President.
Recognize the senator from the 32nd to speak to the measure.
Thank you, Mr. President. House Bill 315 is an update to a bill that we passed last year concerning high-resolution mammograms. Insurance companies already must allow use of the high-resolution mammograms, and it's paid as a preventive benefit, but the bill last year listed a specific guide to be used, which was a 2022 guide, and it should not be limited to just that year. This bill allows the Commissioner of Insurance to designate the guide and make rules and not limit it to that one resource. If there are no questions, I'll yield the will.
You have no questions, Senator.
Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. Report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor of the bill vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 48 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 56.
Thank you, Mr. President. I move we catapult House Bill 412 off the table.
All right, the senator has moved that sling the House bill off the table here, so Secretary read the caption. Is there objection? First. Without objection, Secretary read the caption.
House Bill 412, a bill to be entitled an act to amend Chapter 7 of Title 48 of the Official Code of Georgia annotated, relating to income taxes, so as to repeal a limitation on the types of partnerships that may elect to pay income taxes at the entity level. The Committee of the Senate on Finance recommends that this bill do pass. Respectfully submitted, Senator Huffstetler of the 52nd District, Chairman. That completes the order, Mr. President.
Recognize the senator from the 56 to speak to the measure.
Thank you, Mr. President. House Bill 412 is another great piece of legislation to keep Georgia the #1 place to do business. For those that have multiple corporations and LLCs and LLPs, this allows you to simply file your taxes at the entity level. There is no change in what you pay, and you'll notice there is a fiscal note attached to this, which is absolutely zero. This is a great bill, and I'd ask for your favorable consideration. If there are no questions, I'll yield the will.
You have no questions, sir.
Thank you.
Does any senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor vote yea, opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 48 and the nays are 1. The bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 24th.
Mr. President, I ask that House Bill 132 be lifted from the table.
Senator has moved that House Bill 132 be lifted from the table. Secretary, read the caption.
House Bill 132, a bill to be entitled an act to amend Code Section 8-2-23 of the Official Code of Georgia annotated, relating to amendment and revision of codes generally, so as to require the department to amend the Georgia State Minimum Standard Codes to authorize certain uses of ungraded lumber. The Committee of the Senate on Agriculture and Consumer Affairs recommends that this bill do pass. Respectfully submitted, Senator Goodman of the 8th District, Chairman. That completes the order, Mr. President.
Is there objection to HB 132 being taken from the table? Hearing none, I recognize the senator from the 24th to speak to the bill.
Thank you, Mr. President. I bring you House Bill 132 this evening. It's a great bill for the great people, the great state of Georgia. This bill is where you can take ungraded lumber, what we call rough cut, and build you a barn, a shed, you can even, a pump house, you can even build an outhouse. But you cannot live in it. But this is gives the people, the great state of Georgia, the freedom to choose whether they like to build a structure out of rough cut lumber. I ask you to vote green for the great people of the great state of Georgia. Thank you. I yield the way.
Senators yielded the well. Senator from 53rd has yielded the well. You're welcome to speak on for or against it. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. And the previous question is ordered. Is there objection to agreeing to a report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor vote yea. All those opposed, nay. Secretary unlock the machine. On the passage of the bill, the yeas are 46 and nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Recognize a senator from Perry, Georgia, senator from the 20th, for a motion.
Thank you, Mr. President. I ask for unanimous consent to remove House Bill 557 from the table.
The senator has moved that House Bill 557 be taken from the table. Secretary, read the caption.
House Bill 557, a bill to be entitled an act to amend Chapter 34 of Title 43 of the Official Code of Georgia annotated, relating to physicians, assistants, and others, so as to authorize physicians to delegate the authority to advanced practice registered nurses and physician assistants to prescribe Schedule II controlled substances. The Committee of the Senate on Regulated Industries and Utilities recommends that this bill do pass by committee substitute. Respectfully submitted, Senator Kautzert of the 46th District Chairman. Regulated Industries and Utilities offers the following substitute to House Bill 557. A bill to be entitled an act to amend Chapter 34 of Title 43 of the Official Code of Georgia annotated, relating to physicians, assistants, and others, so as to authorize physicians to delegate the authority to advanced practice registered nurses and physician assistants to prescribe certain Schedule II controlled substances. Senator Huffstetler of the 52nd District and others offers the following amendment. Amend the Senate Committee on Regulated Industries and Utilities substitute to House Bill 557 by inserting before to provide for related matters on line 10 the following. To amend Chapter 1 of Title 43 of the Official Code of Georgia annotated relating to general provisions relative to professions and businesses so as to prohibit enforcement of restrictive covenants under certain circumstances. Amendment 2 submitted by Senator Walker of the 20th and Kirkpatrick of the 32nd offers the following amendment. Amend the Senate Committee on Regulated Industries and Utilities substitute to House Bill 557 by inserting before to provide for related matters on line 10 the following. To amend Chapter 1 of Title 43 of the Official Code of Georgia annotated relating to general provisions relative to professions and businesses so as to provide that professional programs that are established to address career fatigue and wellness in healthcare professionals are not obligated to report to licensing boards. Senators Tillery of the 19th and Walker of the 20th offered the following amendment 2A to House Bill 557 by amending line 14 to read as follows. 43-1-36.1. That completes the order, Mr. President.
Without objection, I recognize the senator from the 20th to speak to the measure.
Thank you, Mr. President. We've heard two recurring themes this session, workforce and healthcare access. And House Bill 557 attempts to address the issues we're having in both of those areas. I've said from this well before that every business owner, every industry I talk to in my district complains of workforce shortages. I'm sure you've heard that from your constituents also. Part of one of the areas where the workforce shortages are the most acute is in the healthcare arena. The governor appointed a healthcare workforce commission because of the concern of this and to try to make recommendations to address the issue. And the recommendation for healthcare workforce are focused on strategies that maximize our existing workforce, optimize our education system, and attract new workers. I've brought a bill in the past before to give a limited expansion of ability for advanced practice registered nurses to administer Scheduled II narcotics, and I'm bringing it to you again today. This bill is a compromise. It includes physician assistants and APRNs, and it does several things. First of all, wanted to let you know that APRNs, on the APRNs, Georgia and Oklahoma are the only states that prohibit APRNs from any sort of Schedule II prescribing. However, Oklahoma does allow CRNAs to administer Schedule IIs. And for PA physician assistants, Georgia and Kentucky are the only states with a blanket prohibition. In many of our counties, there is only a physician assistant or APRN present in the medical facility in that county. Of course, they're working under the direction of an MD, but they're oftentimes the only person there. So what this bill does, under certain conditions, it allows APRNs and physician assistants to provide adult patients over 18 or over, with a limited 5-day course of certain Schedule II medications, which are spelled out on the bill, and it's hydrocodone and oxycodone, or a compound of those. and it has to be in an emergency situation. 5 days, it's got to be an emergency situation, only to an adult, and it has to be part of their protocol agreement with the physician that they work under. It also expedites the post-initial licensure procedure for APRNs and PAs at the Composite Medical Board. So APRNs are licensed by the nursing board, but their protocol agreement with the physician they work with has to be approved by the Composite Medical Board. Once they're initially licensed and their initial protocol agreement is approved, this bill would call for any changes, like let's say that physician retires and they go to work under another physician. As long as the protocol agreement is reasonably similar, when they send in their application to work with a new physician, it would be deemed approved. And it's the same streamline for the physician assistants. And then the third thing that the bill does is it allows APRNs and physician assistants to provide a parking permit for people with disabilities. Now we have, so that's kind of the original part of House Bill 557. You'll see on your desk now 3 amendments. I agree with Amendment 1. It's a friendly amendment, but I think I'll let the senator, the chairman of our Finance Committee, explain this amendment. That's his amendment, but I'm supportive of it. Amendment 2, I was asked to consider adding language from a bill that didn't make it across, and I'm agreeable with that. And what Amendment 2 would do is, you know, we've of course been through a pandemic, and we've asked a lot of our medical providers, and they've been under a heavy workload and a lot of stress. Amendment 2 would provide or allow for these medical providers to seek mental health counseling without jeopardizing their license. So they could be confidentially seek counseling for stress, mental health, depression, those kind of things. That's what Amendment 2 does. And then Amendment 2A, thankfully, my smart seatmate, our esteemed Appropriations Chair, realized that we had a little, I guess you'd call it a Scrivener's error, and that is correcting that. If he had not caught that, basically Amendment 1 and Amendment 2 would kind of offset each other, and that's not what we were trying to do. So be happy to try to answer any questions if there are any, but I'll also be happy to yield the well.
Senator, you have no questions.
Awesome. Thank you all. Please vote green.
All right. Good job, Senator. I recognize the senator from the 52nd to speak to Amendment 1.
Thank you, Mr. President. I don't think I've offered an amendment for a couple of years, so I rarely offer an amendment, but when I do, it's for a reason. There is so let's say a hospital closed in a city like Atlanta. I know that doesn't happen too often, but let's say they closed and they give 30 days notice, and we're going to shut down, and another hospital we're going to close down, and then they say to the employees there that they have under contract, well, we've got to no compete with you, so you can't go to work for Piedmont or Grady or Emory or Northside because we've got a non-compete. Well, wait a minute, my place just completely closed. Well, we got places in other parts of the state, but you can't live where you live and go to work at these places, even though we're shutting the place down. I also learned that there's no non-competes for lawyers in the state of Georgia because I guess they write the laws, so that they have that taken care of. So I want an amendment to address that type of situation. There's other situations where somebody comes in and buys a group out and says, we're cutting your pay in half. Well, I don't want to work there anymore, then I'm going to go work somewhere else. Oh, no, you've got a non-compete. You have to stay here. There are situations where, oh, but they would let you take care of the non-compete for $4 million and you'd get out of it that way. Situations where somebody comes in and says, we're going to cut your pay, but also we've got facilities in Georgia, outside of Georgia, and we reserve the right to move you to one of those other facilities at whatever pay we determine. I mean, that doesn't even sound like America to me. So I don't know how we got in this situation. Had a conversation with Piedmont Hospital last week. I never worked for Piedmont Hospital, but I guess I got a lot of respect for them because they told me we don't have a single non-compete. We don't believe in non-competes. We believe if we take care of our doctors and nurses, they'll want to stay with us. And so we're opposed to non-competes. Now, I'm not trying to eliminate all non-competes. I think we maybe should, but in this particular bill, I'm saying you close a place down, you can't hold them to working there. You come in and take over and you change their pay significantly, and you can't say, you know, no, you can't go to work anywhere else. We've got you under this slavery, it sounds like to me. So that's what these amendments do. They address some things that really are quite shocking to me of what happened out of this. If there's no questions, I'll yield to Will.
You have no questions, Senator? Recognize the senator from the 49th. What purpose you rise?
I ask for unanimous consent to excuse the senator from the 48th for business inside the Capitol.
Without objection, the senator from the 48th is excused. Recognize the senator from the 19th to speak to Amendment 2A. You good? Senator, senator from the 20th, would you like to close debate? You good? All right. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Question is on adoption on Amendment 1, authored by the senator from the 52nd. Is there objection? Without objection, Amendment 1 is adopted. Question now is on Amendment number 2A, excuse me. On 2A, is there objection to Amendment 2A? Without objection, Amendment 2A is adopted. And now finally, on Amendment 2, is there objection to Amendment 2, authored by the senator who's carrying the bill, the senator from the 20th? Without objection, Amendment 2 is added. Questions on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 53 and nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 46th for a motion.
Thank you, Mr. President. I ask that we remove House Bill 196 from the table.
Senator's requested that we move House Bill 196. Secretary, read the caption.
House Bill 196, a bill to be entitled an act to amend Article 9 of Chapter 12 of Title 16 of the Official Code of Georgia annotated, relating to access to medical cannabis, so as to provide that the Georgia Access to Medical Cannabis Commission shall be subject to the Administrative Procedure Act and laws governing opening meetings and open records. The Committee of the Senate on Regulated Industries and Utilities recommends that this bill do pass by committee substitute. Respectfully submitted, Senator Cowser, the 46th District Chairman. Regulated Industries and Utilities offers the following substitute to House Bill 196, a bill to be entitled an act to amend Chapter 2 of Title 2 of the Official Code of Georgia annotated, relating to the Department of Agriculture, so as to provide for the study of the regulation of the production, distribution, and use of medical cannabis. That completes the order, Mr. President.
Without objection, I recognize the senator from the 46th. Speak to the measure.
Thank you, Mr. President. Senators, it's my pleasure to be with you this afternoon to present the committee substitute to House Bill 196. This seems to have become somewhat of an annual tradition here in the legislature as we review the medical marijuana laws. This is a journey that we started 5 or 6 years ago, heck, maybe longer than that, when, if you may recall, Alan Peake had this legislation. None of us had even heard of medical marijuana, and we began to be educated, and we passed bills to allow people to possess it. And then we realized they couldn't get it here from out of state, so we ultimately came up with a system, the Medical Cannabis Commission, that would license producers to manufacture and produce and sell medical cannabis products for all the many different ailments that have been identified that can be helped by this. You know, in many ways, we have failed in this endeavor, because here we are. I was talking to the rules chairman this morning. It was 4 or 6 years ago when we can't even agree when on that simple fact when we started this, when we passed the bill. And it took years and years and years for the commission to get organized, to get its rules and regulations together, to take applications, to grade those, and then award licenses. Not issue them, but award them. And in the meantime, all of these children with seizures and all the people with other conditions that there's pretty strong evidence that medical marijuana products can help have been sitting there waiting. And all the time, the frustration has boiled within this body and within our citizenry as to when are we finally going to do something about this. Well, finally, the licenses were awarded, and the next thing you knew, there were many disgruntled, unhappy applicants for licenses that were rejected that filed legal challenges. The 2 Class 1 licenses, which are the largest producers, had their challenges dismissed, and they have been in the process of manufacturing these low THC oil products and CBD products and other marijuana-based products to get them to the shelves. The 4 Class 4 licenses that were awarded are still tied up in court from 9 different protesters, we'll call them, applicants that did not receive licenses that have filed a variety of lawsuits. Some of those claims are in the Court of Appeals as we speak, and we expect an opinion will be issued later this spring, probably we're out of session, and maybe it resolves it. You know, maybe they dismiss those appeals and the 4 Class 2 licensees are awarded their licenses and will help ramp up the production. Maybe they win those protests because they have a lot of very strong arguments that they were unhappy with the process. It was not transparent, didn't follow the open procedures, open records acts of our state or the Administrative Procedures Act. We're not totally forthcoming, even when the House Regulated Industries Committee asked to get to the bottom of it last year, was just told, sorry, that's confidential, we can't give you that information, which just fed the paranoia of the license applicants that didn't get their licenses. At least tell them why. What was their score? What were they fairly scored? How did they compare to the other applicants that were awarded licenses? And it's been extraordinarily frustrating. In response, the House passed this bill. The bottom line of this bill, it cleans up a lot of the procedures, but it attempted to grant licenses to the 9 protesters so that we would go from having 2 Class 1s and 4 Class 2s to a total of at least 16 licenses, 15 licenses, get my math straight on that. The Senate Regulated Industries Committee sympathize with the plight, but feel like that approach does nothing but reward the protesters that spent the money to hire attorneys and litigate the issue. And it ignored the valid complaints of the other 60 some odd applicants that lost, maybe justly, maybe unjustly, but they didn't hire attorneys and appeal it. So this does not grant any new producer licenses, but we're going to address the underlying problems with the commission. Not going in specific order in the bill, but what it will do is require the commission to follow the Administrative Procedures Act going forward. It will require them to follow the open records laws like all other government agencies are required to do, with exceptions for the privacy laws that in certain circumstances data and information would not be revealed. Would not give new licenses at this time for producers, but it would grant new dispensary licenses to the producers that have been awarded licenses. If they have a dispensary at their production facility, they will be able to dispense the products. And will also be able to dispense the products of the other licensees. So you wouldn't have to just sell your product, you could sell all your different competitors' products as well. Many of these products are directed at specific medical problems, and so that makes sense to get access to our citizens. On the bright side, I'm told by the commission that by mid-April, just a couple of weeks from now, these other dispensary licenses will be issued. And we're told by the 2 Class 1 license holders who are in the process of manufacturing the product that it will be on the shelves by the 1st of June or early June of this year. So there's relief in sight for those patients that have been waiting patiently or impatiently for the last 4 or 5 years to see product be available to them. We have also taken into account the concerns of some of the unsuccessful applicants and people that have pushed for many years that maybe we need more licenses. The more the merrier. You know, there's a balancing act of some type here, and I have always cautioned for restraint. Let's make sure we know what we're doing. Let's get it going, and then let's leave that open in the future if we need to increase the number of licenses that we grant for production and manufacture of these products. Right now, there are 26,000 Georgians that are on the patient registry. They are qualified to receive these medications once they hit the shelves. There have been a lot of estimates that that number will greatly increase over the years as this becomes more available, prescribed more often by physicians, and found to be more helpful to people with these conditions. A couple of years ago when we looked at this issue, the estimates were that that list will probably go to 75 or 85,000 people based on the population of Georgia and based on the percentage of people in other states that end up being on their patient registries. You're not always comparing apples to apples or oranges to oranges because of different populations, different laws, different conditions that are covered, but it would not be surprising for there to be several 100,000 Georgians on these patient registry lists in the future. So this bill builds in the potential for future licenses once our patient registry hits 250,000 patients. And then every 50,000 increase going forward from there, there could be additional licenses issued. The other thing that's been frustrated for many of us is how this has gotten bogged down in court. I'm a lawyer, and I don't understand all the appeals. I am not sure even I understand what the legal arguments are on a lot of these lawsuits. They're complex, they're complicated, and they are filed in different courts. And so we may have a situation with different results based on your venue where you are. A brilliant part of this legislation was to send all appeals in the future to the statewide business court, which will be able to develop a specialization in that area and give rapid, accurate, just outcomes to these appeals if there are any future appeals in the future. Our good friend, former Senator Bill Hamrick, is now the chief judge in that statewide business court, so those matters will be in good hands going forward. If there are further legal disputes, which unfortunately in this society, there are going to be legal disputes. Now, how are we going to keep this clean in the future and make it more efficient other than just the Administrative Procedures Act and open records? We have decided, and this is in the very first section of the law, to allow the Department of Agriculture to do a thorough, comprehensive review of the issues and problems that we're dealing with medical marijuana in its production, its distribution, and its use. And to come back and give recommendations to the governor, lieutenant governor, and the speaker by December 1st of this year. Tell us a plan going forward. Is this commission working? Does he have suggestions or ways to improve it? Would the Department of Agriculture like to regulate this going forward in the future? There is some interest there, and many of you are aware that the Department of Agriculture currently regulates and licenses the growing of hemp. Now, hemp is just a different strain of the cannabis sativa plant. Marijuana and hemp are brothers or sisters. They are the same strain, just really differing mostly by the THC content in the plant. So there's a certain symmetry there, a certain history, ability, expertise in the Department of Agriculture to take a good look at it and report back to us. It is my expectation that by the end of the year, this litigation should be resolved. May not, but I hope and expect that it is, and that we don't have to worry about that. But let's say the appeals succeed, and we toss out these licenses and have to start again. This will give us to be fully advised, knowledgeable, informed on the subject matter to decide which way to go next session. I would urge all of you to support this compromise. I know there are a lot of people that are not happy, that didn't get their way or all of their way in some of this, but I think it comprehensively addresses it in a way that we can be proud of and we can get it right going forward. Mr. President, with that, unless there are any questions, I would yield the well.
You do have a question, Senator. Senator from the 32nd.
Thank you. Will the senator yield?
I yield.
Thank you. I'm just trying to get clarity on the numbers. In other words, there's 26,000 people on the registry that have cards. Do you have any information about how many licenses it actually takes to provide enough THC oil for those patients?
Yes, we had a number of hearings in regulated industries on this issue, not just this year, but in past as this bill has come through there traditionally. Let's put it this way, the 2 Class 1 license holders that have already been issued and are already in the process of producing the THC oil and the products, each claim they can provide enough product to treat 300,000 patients. And that's 2 of them, so that's 600,000, and each of the Class 2 licenses will be able to do about half as much again. So we believe once these, all 6 licensees get actively producing, that it's well enough for over 1 million patients. But it's interesting to have that competition, because by having 6 producers, they can specialize in different types of conditions that they may be developing products for, and it also generates price competition between them. So what we would want to happen going forward is if it's demonstrated that these license holders are not able to keep up with the demand and adequately supply, then new licenses could be extended in the future.
Thank you, Senator. Would you further yield for one more?
Be glad to yield.
I may have missed, you may have already said this, but is the marijuana, misspoke, the THC Commission, Cannabis Commission, whatever we're calling it, is it currently administratively attached to the Secretary of State's office, and you're looking to move it to the Department of Agriculture?
No, it's separate. It's independent. So we're not looking at moving it anywhere. We're just deciding whether or not to keep it open for business going future, or to shut it down and reconstitute a division under the Department of Agriculture to take over those duties.
Thank you.
Thank you.
Recognize Senator from the 30th for a question.
Thank you, Mr. President. Senator Yield,
I yield.
just one quick question. These dispensaries, can we charge sales tax on their product?
I think you can, but I don't know. I'm sorry, I don't know if that's deemed a medical product. Maybe one of the doctors could answer that better than I can.
What classification is THC on the federal level?
It's a Schedule I drug.
Thank you.
You have no further questions, Senator.
Thank you, Mr. President. I yield the will.
Recognize Senator from the 28th. Speak to the measure.
Thank you, Mr. President. I rise today to speak in favor of HB 196. The senator from the 46th and I have been on opposite ends of this issue really since my time here, but there is a few things in this bill that he's captured that I'm in full support of, and just wanted to touch on those with you guys. Number one, and probably one of the most important things we're doing in this bill, is going and putting in a trigger for the licenses, meaning tying those number of licenses to the number of patients on the registry. That is something back 5 years ago when we did the study committee, which I co-chaired with then Representative Micah Gravely. We actually made that recommendation coming out of the study committee, and it did not make it into the final version. And so coming back and doing this now, we may not totally agree on, where that trigger should be, but at least it's there. And so that part of this bill is very important because it's one of those steps that helps take a little bit of the politics out of this and get it into a common sense bracket, which doesn't always, common sense and government don't always go together. So when we can mesh the two, I think that's important. Number two, having a dispensary at the production facility is very important, because if you remember when we issued the production licenses, the way it was drafted was we were pushing them into rural Georgia. So when we talk about access for rural patients, it's important that they be able to have a dispensary in these rural areas, because supply and demand, most of your dispensaries are going to want to attract to your more metropolitan areas. So that's a very important piece. And then number three, I also support the business court. This process that we're in right now has hindered the fact that we're in the courts. We should have had medicine on the shelves a year ago, and we could have been had it not been for the court cases. So if we can kick this into a business court and get it done a lot quicker, again, we're going to be able to get that medicine in these patients' hands much faster. So again, while I don't think this is perfect, it is certainly a step in the right direction. and urge your favorable consideration. Thank you.
Senators yielded the well. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed by substitute. I recognize the majority leader for a motion.
Thank you, Mr. President. I move the Senate agree to the House substitute to Senate Bill 146.
Majority leader has moved that the Senate agree to the House substitute on SB 146. Secretary, read the caption.
Senate Bill 146, a bill to be entitled an act to amend Article 2 of Chapter 2 of Title 46, Chapter 1 of Title 10, and Article 1 of Chapter 9 of Title 48 of the Official Code of Georgia annotated, relating to jurisdiction of and powers and duties of the Georgia Public Service Commission generally. The House offers the following substitute to Senate Bill 146. A bill to be entitled an act to amend Article 2 of Chapter 2 of Title 46, Chapter 1 of Title 10, and Article 1 of Chapter 9 of Title 48 of the Official Code of Georgia annotated, relating to jurisdiction of and powers and duties of the Georgia Public Service Commission generally, selling and other trade practices, and motor fuel tax. That completes the order, Mr. President.
Recognize the majority leader. Speak to the motion.
Thank you, Mr. President. Senators, SB 146 is a bill we've already passed out of the Senate. It's gone over to the House. We made some small changes to the language. A mirror companion bill has already passed the Senate Regulated Industries Committee and is on the table for your consideration today or Wednesday. I'll go over the changes quickly that were made to the bill, and then I'll ask for questions. As you recall, the underlying bill deals with 3 sections. One is it allows for the sale of electricity for electric vehicles to be sold by kilowatt hours and not time. The second portion of the bill deals with the permitting, the inspections, and the regulations that are applied to the EV industry, and it will be authorized to be enforced by the Department of Agriculture through the leadership of the Ag Commissioner. And Section 3 of the bill deals with the taxes that pertain to the replacement of the lost motor fuel tax by the fact that these cars are propelled by electricity and not motor fuel. Specific changes that were made by the House are on line 76, where we made a modification to the definition of digital network, which is just a slight altercation that was suggested by the Legislative Council. The intent should remain the same as the previous version. Line 88, the definition of residence was altered somewhat. Given more time to look at this exemption, Legislative Council recommended the change. It ensures that the power source is on the same piece of property as the vehicle that is being charged. It also worked on definitions dealing with multifamily. If you have the charging stations at an apartment complex for people who would be living there as permanent tenants, people who live there for 30 days or longer. Lines 248 adds that an electric vehicle charging station inspector who is directly or indirectly interested in the manufacture or the vending of an EV charging station shall be disqualified from providing the inspector services until their interests no longer exist. It's basically a conflict of interest clause for anyone working for the Department of Agriculture. Lines 318 of the bill strikes the sunset on the Consumer Price Index inflation measure for motor fuel tax. Line 341 consolidates the gallonage equivalent ceiling to 11 kilowatt hours per hour. That is a maximum rate that they could charge. It's a conversion from 11 kilowatts compared to the gallon of gasoline. Lines 342 includes the hydrogen gallonage equivalent floor that was in Representative Jasper's bill and House Bill 406. It just mirrors that language. And the last change that was made by the House is on line 437, which eliminates the CPI index inflation measure for the annual fee on electric, hydrogen, and propane-fueled vehicles. Mr. President, I'm happy to take any questions, or I'll yield and ask for your favorable consideration for SB 146.
Recognize the senator from the 19th.
Thank you, Mr. President. Senator, you yield?
Yes, sir.
Senator, first I want to thank you for your work on this. I know you spent a lot of time working on electric vehicles generally. I didn't see the electric vehicle commission in this bill. Is it in here?
The electric vehicle
The EV commission that we passed earlier?
No, that's a separate bill. It was not included in this bill ever.
Since we are now in a position back and forth between the House and the Senate, would you consider it a friendly amendment for an amendment to add the EV commission to this bill?
I'm assuming that bill is still alive and well in the House going back and forth, so I would prefer to keep it separate if possible.
Okay, thank you.
Considering the time that we have to make that amendment.
Thank you.
But thank you.
Recognize the senator from the 37th.
Thank you, Mr. President. Does the gentleman yield?
I do.
Appreciate your work on this as well. This is an important subject matter for us. I was a little confused on line 341.
Yes.
It was my belief that the electricity equivalent of 11 kilowatt hours would be framed as not less than 11 kilowatt hours, because what that does, that would have the effect of capping the tax rate. If it's not more than 11 kilowatt hours, that would have the effect to allow the tax rate on consumers to rise. That may be something that was missed in this process. I know we spoke about that.
Yeah, so the 11 kilowatts would be the denominator in the equation, in the conversion. So you take the gas tax on a gallon of gasoline, let's say it's 30 cents.
Yes, sir.
To equate that to the kilowatt hour, you would divide the 30 cents by the 11. So by changing that from 9 to 11, it actually lowers the tax rate for the electric car.
Yes,
because
sir.
the denominator gets larger and not smaller.
It was my understanding that the agreement was, does the gentleman further yield?
Yes, sir, I do.
It was my understanding that the 11 kilowatt hours was going to be the minimum. To the gentleman's point, if it was raised from 11 to 12 or 13 or 14, that would have the effect of moderating and bringing down the tax rate on consumers. A not more than 11 cents would allow the tax rate to rise on consumers. And I think, I was just going to ask you, is that intended? And would the gentleman consider a friendly amendment to address that issue?
I think the intent is to do what it says, and that is to allow for that rate to be raised from 9 to 11, not to be a floor, not to be a ceiling, but to be a floor. But as time goes on and inflation rises, the dollar value of a dollar will continue to decrease. So if the gasoline tax goes up to 35 cents per gallon, then that rate would also go up with the electric car. So it would create parity. What we're trying to do is to make sure that the people driving a gasoline-powered car is paying the same rate as the person that is driving an electric car and vice versa. So it's to allow for those two tax rates to be basically parallel to one another. Thank you.
You have no questions, Senator.
Thank you very much. I appreciate your favorable consideration.
Recognize the senator from the 6th. Speak to the measure.
Colleagues, I rise briefly to appreciate the majority leader for the work on this bill and to also highlight something that was brought up by the senator from the 37th, but also others related to the bill, which is that there's still work to be done. I appreciate the fact that this bill doesn't go into effect until 2025, but I do think that there are some things that we need to think about related to EV drivers and the fact that at this point we have one of the highest registration fees in the country, and this tax, as currently written, would be the highest tax on EV drivers in the country, which, you know, if the intent is to target out-of-state drivers driving through Georgia, makes perfect sense, but it would also impact residents who live here and who are helping to make Georgia the EV capital of the country. These very workers would be driving EV vehicles and paying the highest taxes in the country, which doesn't seem to make sense. In addition to that, the bill does require employers in Georgia to retrofit their chargers to meet the requirements of this law, which would not only cost the employers money, but would affect an employee benefit that many employers use, which is to allow employees to charge while they're at work. This bill would actually prohibit that. Which is concerning and something I think that if we are truly concerned about consumers and particularly about these out-of-state drivers, then we want to make sure that in-state employees that are working for Georgia companies aren't impacted by this. In fact, the Georgia Chamber letter talked about how this bill targets consumers, but the indirect or the direct fallout from some of these provisions is that it will also impact Georgia employees, which I know we all don't want. And I've had this brief conversation with the majority leader, and we've certainly agreed that there is work to be done, particularly in the future on this bill. So I just wanted to highlight the fact that there is still work to be done. And while I appreciate the effort that has been done here, let's continue to work on making sure that Georgia is the electric vehicle capital of the world. I yield the well.
Does any other senator wish to speak for or against the measure? Chair hearing none. Senator has agreed to the position. Senator from the 24th, for what purpose do you rise?
Mr. President, I'd like to excuse the senator from the 23rd doing business inside the Capitol.
Without objection, senator from the 23rd will be excused. Majority Leader has moved that we agree to the House substitute on Senate Bill 146. All those in favor will vote yea. All those opposed, nay. Secretary, unlock the machine. On the passes of the bill, the yeas are 51 and the nays are 4. And just like that in a flash, Supercharge over there has passed his EV bill. The bill is passed. Congratulations, Senator. You worked hard on that. I recognize the senator from the 8th for a motion.
President, I move that the Senate agree to the House substitute to SB 220.
Senator from the 8th has moved that the Senate agree to the House substitute on SB 220. Secretary, read the caption.
Senate Bill 220, a bill to be entitled an act to amend Chapter 10 of Title 44 of the Official Code of Georgia Annotated, relating to historic preservation, so as to establish the Georgia Farmland Conservation Fund, Georgia Farmland Conservation Fund Program, and Georgia Farmland Advisory Council. The House offers the following substitute to Senate Bill 220. A bill to be entitled an act to amend Chapter 10 of Title 44 of the Official Code of Georgia Annotated relating to historic preservation, so as to establish the Georgia Farmland Conservation Fund, Georgia Farmland Conservation Fund Program, and Georgia Farmland Advisory Council. That completes the order, Mr. President.
Chair recognizes the senator from the 8th.
Thank you, Mr. President. SB 220, the Georgia Farmland Conservation Act, you all have seen it before. This is just some minor changes that were requested by Legislative Council. The changes were lines 19 to 35, where Legislative Council wanted to strengthen the legislative findings to address any future challenges of the gratuities clause and the addition of the definitions of agricultural conservation easement and conservation easement in lines 38 to 45. That ties this bill back into another section of Title 44 where conservation easements are already defined and discussed in statute. That is the simple changes that were made. Be glad to take any questions. If not, I yield the well.
Senator, I see no questions.
All right, thank you, Mr. President. I urge your favorable consideration.
Yep.
Thank you. Yield the well.
Chair recognizes the senator from the 49th.
I request unanimous consent to excuse the senator from the 48th.
Your request is approved. Senator from the 48th is excused. Say again. Without objection. I'm running with no script up here, guys. Y'all be good to me. Be good to me. All right. The senator has agreed to the House substitute to Senate Bill 220. Do any other senators wish to speak to the bill? Seeing none, we'll stand by for the Lieutenant Governor to come take over from here. You memorized well.
Just like the volleyball game the other day, guys. I left, wheels start coming off. I'll tell you what. Kickball. Well, there you go. I didn't even know what game we were playing. So, all right. So the Senate has moved SB 220. We've agreed to the House position. Is there objection? Without objection. All those in favor of the motion will vote yea. All those opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 50 and the nays are 2, and this measure has been approved and is passed. So we've got our page here. What's her name? Hannah Cortez is going to hit the gavel. Let it go, Hannah. All right, all right. Good job.
Thank you,
Hannah.
sir.
Good job, good job, good job. Good job, Hannah. Where'd my pen go? Recognize the senator from the 46.
Thank you, Mr. President. I move that the Senate agree as amended to the House substitute to Senate Bill 74.
All right. But the senator from the 19th is your bill, so you have a motion too.
Thank you, Mr. President. I would move that the Senate agree to the House substitute to Senate Bill 74, but I do understand that the agree as amended takes precedence, and I look forward to responding to the senator from the 46th.
Okay. All right. I tell you, you lawyers, y'all are something else, man. Recognize the senator from the 19th. Recognize the senator from the 19th. Okay, I'm sorry. Senator from the 46. I apologize. Read the caption.
Senate Bill 74, a bill to be entitled an act to amend Titles 10, 15, and 51 of the Official Code of Georgia Annotated, relating to commerce and trade, courts, and torts, respectively, so as to require the disclosure of the nature and practices of businesses that provide legal services. The House offers the following substitute to Senate Bill 74. A bill to be entitled an act to amend Titles 9, 10, 15, 50, and 51 of the Official Code of Georgia Annotated, relating to civil practice, commerce, and trade, courts, state government, and torts, respectively, so as to provide for definitions to change and provide certain provisions relating to legal proceedings and legal services, to provide for protective orders for certain high-ranking members of a governmental body or public or private entity. Senator Cowsert of the 51st offers the following amendment. Amend the House Committee on Judiciary substitute to Senate Bill 74 by deleting unique and on line 50, by adding large after any and after other on line 51, by replacing private, that is large and complex, with private on line 52. That completes the order, Mr. President.
Recognize senator from the 46.
Thank you, Mr. President. Senators, you know, I have a speech, we all do, that I give to chambers of commerces and civic clubs that I say one of the things that is so gratifying and stimulating about this job is it's like going to several different seminars a week. So today I've already talked about domestic terrorism on our critical infrastructure. We've talked about medical marijuana, and now we're back in the world of law in the Civil Practice Act. How do we handle depositions of high-ranking government officials or corporate officials? You may remember this bill was before us previously, Senate Bill 200. It was amended on the floor to the point where it was fairly well obliterated of having any meaningful impact, and it was ultimately placed on the table where it died a peaceful death there before crossover day. This bill is a bill from the senator from the 19th bill that's in the back, starting at Part 2, and that dealt with false advertising for legal services, basically. I will not speak to that piece of the bill. I voted for it in the Senate. I'm fine with it as it came back from the House, unless the senator from the 19th has problems if they made any changes to that part. My problem is they put on this in the first few pages Part 1, basically pages 2 and 3 and a little bit on the top of page 4, what was originally House Bill 530. And House Bill 530 was assigned to the Senate Regulated Industries Committee, where we vetted it, we looked at it, and even though it was completely more supportive of the plaintiff's bar than the original SB 200 was to protect businesses, to keep our state the #1 place to do business in the country, this one was not nearly as favorable to business, but was favorable to the plaintiff's bar. As we vetted it, we changed 2 words in this bill. Just 2 words from the House version, and I'll tell you what those were. And now they have taken their original bill to avoid that minor tweak and put it on another Senate bill, thinking they could slide it by us in the agree-disagree process. Thank goodness that we had a little time over the weekend to look at our rules calendar. Remember, we met in mid-session on Thursday, and so I had time to know what was coming today to catch this being tucked onto a completely unrelated bill. So let's review again the issue, in case you don't remember from the last time we handled this back in ancient history. Feels like it, doesn't it, crossover day? What this bill was in response to attempts by plaintiffs' lawyers to take depositions, questioning them under oath of corporate presidents or high-ranking government officials, which some of us in this room have been deposed in connection with some recent litigation, and realize sometimes you're being asked questions that you don't know anything about. Just because you're a member of this organization, or you're a high government official, or you're a high corporate official, doesn't mean you have any personal knowledge of the issues involved in the lawsuit. Many states have something they refer to as the apex doctrine. Think about the Christmas tree. The apex is the top. When you're taking depositions from people at the top, they don't necessarily have information or knowledge about the issues that are in dispute, like the design of an automobile, which was this General Motors case that sort of generated this discussion in the state of Georgia recently. Or whatever type of manufacturing organization you may, if you're the president of a pharmaceutical organization, you don't know who did the clinical trials and exactly how they turned out. You've got scientists and chemists and other clinical specialists that are finding that information out for you. Well, these states that have an apex doctrine, some of them have them by statute, and SB 200 that failed here on crossover day was based on Florida's statute. Florida's a very business-friendly state. And I think they're thriving because of that. They got no income tax. They have a very ambitious governor who has just passed an enormous tort reform package there to great acclaim. And they have an apex doctrine and statute that protects their corporations from being harassed by depositions, having to set aside their schedule to answer questions and be embarrassed and try to be leveraged into settlements. Other states don't have it in a code, but the courts have created the doctrine through their judicial opinions. And we refer to that as the common law versus statutory law. Georgia has neither up until today. And this is an attempt to codify an apex doctrine to protect high government officials, high corporate officials from being harassed in depositions on subject matters that they have no personal information about. Now, I have an amendment here that essentially reinserts the Senate Regulated Industries substitute, putting those 2 words, or basically taking them back out of the House version. And those 2 words are unique and complex. The basis of this apex doctrine is if the person being deposed, being questioned, does not have personal, unique knowledge about the subject matter in the lawsuit, that they can claim, I'm not the right person for you to depose, and ask for the court to give them a protective order. Under the House version, in addition to them having to have that unique personal knowledge, the corporate official or the government official has to show that they have a unique schedule and that they are working for a large and complex organization. All we did in the Senate side was say, you shouldn't have to have a unique calendar. If you've got a stressful, steady, problematic calendar, that ought to be enough. It doesn't have to be unique, like you're the only corporate president in America that has this type of schedule. And it doesn't have to be a complex organization you're working for. If it's a large corporation or a large business, and you have a busy schedule and you don't have unique knowledge of the information, you shouldn't have to be submitted to a deposition. And so you would still have the obligation, the burden of going to court and asking for a protective order. Please protect me, don't make me have to go to this deposition, and explain your burden of proof. Why? That you don't have personal knowledge about it, unique knowledge about the subject matter, and that you have a busy, hectic type schedule, even though it might not be a unique schedule. I had this amendment that puts those words back, or basically takes those words back out, only in the scheduling part. And it also makes it clear that this new law that's aimed at corporate officials and high government officials does not undermine the existing Georgia law, which allows you to seek a protective order if something is annoying, harassing, unduly burdensome, and a series of other things. Wanted to make sure that by creating protections for high corporate officials, we didn't raise the bar for everybody else also to be protected from abusive discovery techniques. I hope that explains it. Sometimes I just want to pull my hair out how us attorneys will dibble and argue and fuss and fight over a couple of words. Our rules chairman was in the Regulated Industries Committee and I wish I'd written it down. Maybe we could have had the puppet lady do it. He said something like, really? Is that all they're arguing about? This is obvious. You can't make somebody have to prove they have a unique schedule to be able to get the benefits and be protected from this harassment. I'll point out you will have on your desk a letter of support from the Georgia Chamber of Commerce. This is an important issue to them. This is a scorecard issue for them. And all the other business organizations in the state are to the point where they're getting afraid to do business here because the deck seems so stacked against them. This Site Selection magazine that says we're the best place to do business, it doesn't take into account the legal environment or the judicial system. It looks at the economic development support, the tax benefits, the workforce. Let's don't let our state get to the point where businesses are fearful to do business here because they're subjected to unnecessary litigation, unfair litigation tactics. Let's let them know how important business is to us. And trial lawyers, can you stand down on two words, complex and unique? It doesn't undermine your abilities, but it keeps you from making the bill meaningless by making it so hard to utilize that it doesn't help any corporation. Mr. President, I'm happy to take any questions there may be.
You do have a couple questions, Senator. Senator from the 17th.
Senator Yield.
I yield.
Senator, if you'll look at your amendment on line 3 of your amendment.
Yes.
Where you're adding the word large. I have two questions on this. First, you're adding the word large after any, but looking at line 51 of the bill, there's actually two any's there, correct?
Yes.
So is your amendment not in order when it comes to?
What it's saying is it's putting it in both places.
Okay, so if we read it as you're saying that, then it'll say organization includes any large governmental entity and any large other large organization.
I think it should say any other large organization, public or private.
Your amendment doesn't say that, right?
I'd have to check with legislative council. That's the intent. Let me see.
Well, and the other issue is you said you
No,
want to.
it says after any and after other.
Correct. But if you put large after both any's, which doesn't say that, but it doesn't say which any.
You're not putting it after both any's. You're putting it after the first any and after the second other.
Well, do you further yield?
Yes.
The problem is your amendment doesn't say that. Your amendment says you're going to put the word large after any. Any is written in two places. So your amendment says you're not correct, or we can read it as it's written, and the sentence will then say organization includes any large governmental entity, any other large organization, correct?
That's the way it should read. I think that's the way it.
And that's what you want to put in code.
I'm sure the code folks will straighten that and make it right. That's the way I read it. I can see how you could do it. See, here we go.
Do you want to try to do another amendment?
If there's an amendment A, I'd be receptive to it. Do you think you can clarify that?
You asking me?
Yeah, do you think you can clarify that with Amendment 1A? If not, I'm happy to do that while we're
Well, I'm not going to
listening.
write your amendment for you, Senator. I'd rather go back to the bill that's passed by the House.
See what I can do.
Recognize Senator from 36.
Thank you, Mr. President. Does Senator yield?
I yield.
Is it accurate to say, or it seems to me common sense to say, isn't it true, that most anybody getting sued and getting deposed is not crazy about that process? They'd rather not do it in most cases.
Most of the time.
Most of the time. And it's hard to understand why the people at the pinnacle in their corporations shouldn't be willing to stand for a deposition.
The reason is they don't want to be asked about things they don't have any personal knowledge about. And it's unreasonable to expect that a corporate president is going to have finite duty information about the duties of every person in a 10,000 member organization. That's why this only applies to large organizations. And only if you don't have unique personal knowledge about it. That's what's unreasonable, is to question people that you know don't know the answers and aren't expected to know the answers to these detailed questions about perhaps the design of a product or the compounds in a pharmaceutical product.
But isn't it true that we've often learned upon, with, say, some of these large cases, say with the tobacco industry, as the depositions and as the legal case moves forward and you get a person in a high place in a corporation on record in a deposition, you can learn things that you would not be privy to otherwise.
If
For
they have
example, that yes, we hired a firm to spread false information and use a rigged survey and a rigged, bogus science, and that's how we came up with this allegation that tobacco doesn't harm your health. That's just an example of a very large corporation facing a lawsuit. So it just would seem to me that this could provide blanket coverage for accountability at the highest levels of a corporation if you cannot get to them with a
cursory review, and maybe due to the limited comments I gave, I could see where you would think that. But this bill anticipates that. And down in lines 54 through 57, the burden shifts back. If I were to say, I don't want you to depose me, and you were then able to show the court, I have exhausted all other means of discovery, and it's been inadequate to give me these answers I need, and say that person that's trying to get protection does have unique knowledge of one or more matters related to the subject matter, then you can get the deposition. So that's all you got to do. If it turns out that there is something unique that that person knows and that you can't find it out any other way, you explain that to the judge. And then you're allowed to go forward with the deposition. And it even gives the judge the ability to restrict the questions to those areas and to balance the interest of both parties. And that's all we're trying to do here. Let's don't be unduly burdensome on a corporation if the person doesn't have the knowledge. And it's easy for the plaintiff to find that information from asking the people that do. If they can show the court, I can't figure this out any other method I can find out. And by golly, I got proof that that person does have some knowledge about it. then the judge is going to allow the deposition to go forward.
But isn't it true that what you just described is like getting through the eye of a needle?
No.
Getting a
If
camel
we
through
put
the eye. No,
unique in
if
here,
I could finish my
yeah.
question, that process you described it creates a barrier to accessing that top person in the corporation, and you don't necessarily know, as the plaintiff that's seeking that information, the plaintiff's attorneys, you've created a barrier to their getting access to what information that could be vital. It just seems to me highly protective and tilted, kind of tilts the playing fields.
Maybe so. And,
Yeah.
you know, we're down to, I think we got 8 lawyers in this room. And out of us, very few actually litigate cases. And it wouldn't be obvious to you, but to those of us that are in that jungle fighting for a living all the time, we recognize there are other methods that you can use. And one of those, the attorneys will know, is called a 30B6 notice of a deposition, where you can ask the corporation, here's what I want to know about. Who designed this product? Who did the safety testing on it? You know, who made the decision whether or not to make the recall? You can ask to depose the person that has the knowledge that you want to know. And you can make them designate you a corporate official that can answer those questions. So you don't necessarily start with the person at the top. If you know the information you need, there are other provisions in the Civil Practice Act that allow you to ask for the person that the corporation has to tell you, I'm not going to give you a guy that's going to stonewall you. I'm going to give you the guy that knows what you want to know. That's how you get around this. And if you don't accept that, and you think, well, you know what, I think this president might have some particular knowledge about it, then you ask to take their deposition. And if they come back and go to court and hire lawyers and take the effort to say, we want a protective order under this law that we're trying to pass today, they have to swear, they have to show, I don't have unique knowledge about these issues in the lawsuit. And this is unduly burdensome on me because I've got a hectic schedule and I'm working in a very large corporation, can't be expected to know this. And what the House wants to do is to make you say, in addition to that, you have to show that you've got some type of unique schedule that nobody else in America's got, and that you're in a very complex organization. It doesn't protect the other folks.
But it seems to me, isn't it true, that this is an unlevel playing field when you take that unique that language out of the current law, and that's the concern that many would have about people in high places being protected by this language that you're attempting to amend.
I know, and I'm sure you've been lobbied on that, and that's why I'm glad you're able to be open-minded and listen to me explain how it really works. Because Georgia has been designated as the #1 judicial hellhole in America. If you're a corporation, these rules that you're talking about, a level playing field, are not level. They're tilted against the defendant, against big corporations. And you know what? When they say judicial hellhole, they don't mean we got judges that are horrible. It's the legal laws that these judges are enforcing that make it the hellhole. And that's what we're trying to straighten out, is balance this playing field up so we're not harassing corporations that we're then asking to come here and hire our citizens and give us jobs.
Final question, if you will yield.
I yield.
Isn't it true that if we are reportedly for 9 or 10 years now the greatest state in the country to do business in, that if we did in fact have a judicial hellhole, we wouldn't be drawing all these corporations to come here and invest and build plants and hire people as they are doing today? Isn't that true?
The reason for that is because Site Selection magazine that gives those ratings will tell you the judicial environment is not even a factor that's measured in deciding. And we ought to be grateful to God that it's not, because we wouldn't be #1 in the country. We'd be far down the list, and we wouldn't be nearly as appealing to these businesses by our other economic development incentives, our tax incentives that we do, our workforce that we use, our transportation system that makes it appealing. They don't even put in that calculus what our judicial system is like and what these civil practice laws that we pass and these laws of evidence we pass and these different tort laws that we pass, how they impact that system. And these nuclear verdicts that we keep seeing, these gigantic verdicts that people look at them and say, how can that be fair for CVS to be held liable for somebody getting shot in their parking lot? not even in their store doing business. Why would a CVS open up in a place like Buckhead that's unsafe?
I don't know.
You
They
know.
got about 1,200 sites, I think, in Georgia. So
You watch them close. I can tell you that the store in about just a very few blocks from my house shut down for that reason.
I think I've had enough, taken enough of your time, Senator, and I appreciate the dialogue. Thank you.
You have no more questions, Senator.
Thank you. I yield the well.
Secretary, read the amendment.
Senator Hatcher from the 50th offered the following amendment number 1A by amending Amendment 1 to add, "This bill shall become effective when signed by the governor." Mr. President, that completes the order.
Recognize the senator from the 50th to speak to the amendment.
Thank you, Mr. President. This amendment is just to make sure that that portion of the bill does have an effective date. So, thank you. I yield the well.
Right. Recognize the senator from the 19th. Speak to the measure.
Thank you, Mr. President. A lot of stuff has been said, so I hope I can help you wade through it and provide a simple course that just gets you to the end of this bill for today. Senate Bill 74 began as a lawyer advertising bill. Heard the senator from the 46th, who's my good friend, say a lot of things that I think are true. He said some things that talked about where we stand currently with our judicial system. And I think attorney advertising has gotten to a point where the puffery, the stuff you're allowed to say, like I'm the best senator or you're the best senator, that's protected speech by the U.S. Constitution, has led to falsity. It's not true when the guys stand on top of trucks and say, you know, they're the strong arm. What does that even mean? And that falsity has now led to a belief in our legal system has perverted the way that I think folks think about our legal system. That's all Senate Bill 74 was meant to address, was attorney advertising, and simply say, if you're going to advertise about something as important as our judicial system, we think you ought to tell the truth. And if you don't tell the truth, you can be sued for it. And you can't just be sued for it. You can be sued in a class action for it. We think that protecting the integrity of the legal system is that important. When it went over to the House, it did get a few amendments. One, we didn't make it very clear if the penalty, the $500 penalty, was per advertisement or it was per the number of people who saw it. And that's kind of confusing because if it's a billboard that says this and you go down I-75, is it $500 times the 2 million people that passed it that day? Or is it $500 per the billboard? And the House fixed that. And I appreciate that. They also added on what you've heard the senator from the 46th refer to as the apex doctrine. Why is it called the apex doctrine? Because the apex is the pinnacle, right? The top. And it's an agreement that I think defense and plaintiffs' attorneys agreed on that said, hey, it really isn't fair to drag the top person of a company in, the CEO for Coke, and ask him why the can exploded in McRae, Georgia. He might not know that answer. But what the apex doctrine as it came over from the House said was, hey, if that CEO wants to be protected, he can then say, I have no specific knowledge about the Coke can in McRae, Georgia. I don't know what the temperature was in McRae, Georgia that day. Have no idea about the aluminum they got from wherever they did to make it. And therefore, I should have a protective order that protects me from having to talk about that Coke can. The burden then goes over to the plaintiff, the person who said, Mr. CEO, you should know something about that Coke can in McRae. And the plaintiff has to show two things on lines 60 and 61 and 62. That they have no other way of knowing what happened to that Coke can that day, what the temperature was of the aluminum used, and that that person who they want to depose has specific, unique knowledge of getting it. The version the House passed protects the apex of corporations from having to show up if they don't know anything. The senator from the 46th said the reason we want this amendment is because people don't want to be drug into court, CEOs don't want to be drug into court to be asked about things they don't have no knowledge about. Well, they're protected from that already in this bill. Look at line 64. You see, first of all, if they bring that order and the party can't show that they have specific knowledge anyway, they're protected. Then there's a catch-all afterwards that says, to the extent that the party seeking the protective order shows that an officer lacks unique personal knowledge of some but fewer than all relevant matters, then the court may limit the scope of the deposition accordingly. There's already a second fallback scope measure in this bill. We were told that this was what was added on was the Senate's language, but that would be Senate Bill 200. It never passed this body. It didn't make it out of the conversations in other rooms. We were told that this building, that we have a judicial hellhole, and then one of the other senators brought up that we're number one for doing business. And I do disagree with the senator from the 46th that if all these things were included, we'd be way down the list. I think the governor and this body and the body across the hall have done an amazing job of championing Georgia, and I do not subscribe to the notion that we're anything except number one for recruiting business. There was a mention of nuclear verdicts. Well, why would we not pass this as it is to protect those CEOs, to protect in those situations? And last but certainly not least, the reason why I would ask you to oppose this amendment is the exact same reason that I didn't put an amendment on the last bill of the senator from the 51st. I asked him, should I put an amendment on about EVs, the EV study committee that we cared a lot about? And he said, no, I think that's moving somewhere else. But the other part of that is this. If we put an amendment on right here, what happens? It has to go back across the hall and get voted on again. We're now in the last 36 hours of session, and we have a chance to reject this amendment and pass this bill that does substantially what the senator from the 46th is asking, and it's done. We know it's over, and it doesn't go back from the hall, across the hall for ties up in games that just fell on day 40 for waiting for another year. So how do we get there? Well, that's where I need your help. There's a motion to agree as amended. If you open up your Senate rule book, you'll see in special orders that a motion to agree as amended takes precedence over a motion to agree. That's why, even though this is my bill and I move to agree, the senator from the 46th amendment to agree as amended, he got to speak first. So for my motion to agree to finish this issue and cap it off and be done, to have a chance, we have to vote down the motion to agree as amended, and that's what I'm going to ask you to do. And then I'm going to ask the president if I can make a motion to agree immediately thereafter, and then ask you to agree to the bill, the House version, the House substitute to the Senate Bill 74, and then we will be done. You will have passed the Apex Doctrine, and there will be a tort reform bill that makes it through both chambers this year. That's what I ask you for. I hope you'll follow me on it. Mr. President, I'll yield for questions.
You have no questions, Senator.
Thank you so much. I yield the well, and I guess ask again that you vote down the amendment and that you wait on me then to make a motion to agree.
Senator. Senator from the 8th, what purpose do you rise?
The senator yielded. I was just going to ask him if he could draw a diagram for me to keep up with all of everything he just said.
I can shorten it. He said his stuff's good and the other stuff's bad. Not my opinion. That's just what he said. Senator from the 6th, you'd like to speak? Senator from the 18th. Okay, the posture we're in right now is the amendment which is in order is on is a senator from the 50th on his amendment 1A. Is there objection to amendment, and then we will ask the ups question, okay. So amendment 1A, senator from the 46th objects to amendment 1A. And Senator, you can go ahead and close the debate now if you like with your objection.
Thank you, Mr. President. Well, I may have seen it all now. I've got the governor's floor leader trying to kill this bill to protect business in Georgia, and the governor, high government officials, because the senator from the 50th knows full well that our rules only allow you to amend an amendment once. And by adding this silly amendment, only changing the effective date of this bill, he prevents me from fixing the glitch that our Judiciary Chairman showed, if it's even a potential glitch. So yes, I am against 1A. The effect of that would be that now a governor could only ask for a protective order if somebody's harassing him in a 6 or 8 hour deposition on some subject matter he knows nothing about, unless he can show that he has a unique schedule. Now, what the heck does that mean? Something different from every other governor in the country? Something, what is unique is one of a kind, right? He's making our governor and all of our department heads have to go show that they have a schedule that nobody else has, or else they're not even eligible to bring this motion. Not only do they not have knowledge, but they can't even ask for protection unless they can show that they have a unique schedule and they are the head of a large and complex organization. Think about that at any level of government and any levels of business. This is only available to the high-ranking officers, which we have defined as people that have these extensive schedules that are unique and hard for them to find the time to be sitting down giving a deposition. A high-ranking officer, according to this House version, means somebody that has unique and extensive scheduling demands or responsibilities. So how do you prove that to the judge? I don't know if he's bringing this in his capacity as the governor, as floor leader, or as a private plaintiff's attorney. But this Amendment 1A guts the bill because it tries to keep, and that's what everybody here is trying to do. They're trying to make it dadgum near impossible for a government official, including a lot of us in this room, or a high corporate official to get protection from the court. I ask you to reject this. Let's pass the bill with these tiny changes. They're getting 95% of what they wanted across the hall. Every other word's left fine, except these two words of who it applies to. They're essentially making an exception that swallows the whole, where nobody can take advantage of this unless they can prove to the court that there's something about their schedule that isn't just extensive, but it's unique. It's a one-of-a-kind thing, and it doesn't tell who it's unique as to: other human beings, other corporate officers, other government officials, other people at your same position. It is built to kill the protections that the bill was intended to do. Stick with our business community on this. Chamber of Commerce and all the businesses that support this and want to be able to continue doing business in Georgia. Vote against Amendment 1A. Vote for Amendment 1B that fixes the potential glitch. I'm not sure it even is, the order of where you put large after other or after any. and support agree as amended by Amendment 1. Thank you. I yield the will.
All right, we have a late arriving amendment, Amendment 1B. Amendment 1B. Secretary, read the caption.
Council to the 46 offers the following Amendment 1B, amend Amendment 1 to the House Committee on Judiciary, substitute to SB 74 by replacing line 3 with the following, by adding large after includes any and after any other on line 51.
He did. All right, so now we're in the posture, we're going to take up Amendment 1A, authored by the senator from the 50th. And there is objection from 1A. Senator for the 46 objected to 1A. All those in favor of 1A will vote yea. All those opposed, nay. Secretary, unlock the machine. Recognize the senator from the 46.
Senator, Mr. President, this amendment does not identify what bill it is, what it's amending. 1A, it doesn't identify it by the Senate bill. It doesn't identify it by the LC number. This is a defective amendment 1A. Move that it be stricken.
Senator, the vote has already started. On the passage of the amendment, the yeas are 34 and the nays are 20, and this amendment has passed. Senator from the 46, what purpose do you rise?
Motion to reconsider on the grounds that it's an inappropriate amendment. It doesn't state exactly what we're amending there. It doesn't identify it clearly. And for general purposes, to reconsider that vote.
All right. Senator has asked for a motion to reconsider. Is there objection? Object from the senator from the 19th. All those in favor of motion to reconsider will vote yea. All those opposed, nay. Secretary, unlock the machine. On the motion to reconsider, the yeas are 15, the nays are 40, and the motion to reconsider has failed. All right, so now we're on the senator from the 46 base motion of agreeing to amend. All those in favor of the senator's position from the 46 will vote yea. All those opposed, nay. Secretary will unlock the machine. Senator from the 14th, what purpose do you rise?
Mr. President, parliamentary inquiry.
State your inquiry.
Is it not true that this is the most that any human beings have ever discussed the Apex Doctrine?
I think the senator knows what he speaks. On the original motion by the senator from 46, the yeas are 11 and the nays are 45, and that motion has failed. Now we go to the author of the bill, senator from the 19th, to now his motion will be in order. So, Senator.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 74.
All right, Senator has moved that he agrees to the substitute from the House substitute. Is there objection? There is objection. Would you like to speak to the bill, Senator?
Thank you for sticking with me this far. I just ask you vote green one more time. Thank you a lot.
Recognize the senator from the 31st. You like to speak?
Thank you, Mr. President. I know everybody's having fun with this bill in this room, but at the end of the day, this bill does not help Georgia. And we could talk about the economy, what's going on. I'm sure, and somebody in here will chastise me about citing the state of Florida, you know, in terms of them doing real tort reform. And I'm sure there's going to be trial lawyers coming from Florida crossing that southern line down there, the senator from the 13th district coming over here filing more lawsuits. So we can do what we want at the end of the day, but this is ridiculous. Vote red. Thank you, Mr. President.
Senators yielded well. Senator from the 17th, you still like to speak. Senator from the 18th, you'd like to speak.
Thank you, Mr. President. So why are we here? What are we talking about? What is the issue? What are we trying to fix? What is the problem? Well, we've gotten down this path and we've talked about all these procedural issues and stay with me on this one and let's do it on that one and what's going on over at the House. And we've lost sight of what this bill is fundamentally about and what we ought to be trying to fix. Okay? And it's simply this, that there are times that lawyers inappropriately use the rules of civil procedure to make people that are at the head of an organization, be it a CEO or a governor or someone in charge of a governmental entity, sit for a deposition when they don't know anything about the fundamentals of the issues in the lawsuit. Now, why would they do that? Why would a lawyer do that? Well, follow me with just a little bit of math here. There's 365 days in a year. So what do we work? Maybe about 300 days a year? And if you're an apex person, if you're a CEO of a large corporation, take one of the big automobile manufacturers. How many lawsuits do you think they have about their product liability? And go on down the line. A whole lot more than 300. So what's one of the things you could do to put pressure on a company, to settle with you at rates that aren't reflective of what the case is really about? You've just harassed and harangued them enough, they're going to pay more than what the case ought to pay or what the justice system would otherwise provide. How many suits do you think, pick any one of the automobile manufacturers, do they have pending at any one time? Several hundred, couple of thousand? So it doesn't take much math to see that crafty counsel could actually tie up the presidents of companies every day, working day of the year, just for the purpose of having to sit for, in federal court, you can have to sit up 7 hours for a deposition. That's what we're trying to prohibit. Why? Because, folks, that is fundamentally, and I'm going to use a non-lawyer word, that just ain't fair. It's not fair to make folks sit for those depositions when they don't know anything about it. I'm not going to get into the and back and forth about the wording of this or the procedure of this. I think we lost sight of what the bill is trying to do. What is the Apex Doctrine trying to establish? What is it trying to protect? And it is just a recalibration in making sure that when lawyers use the federal rules of civil procedure or the Georgia rules of civil procedure to take a deposition, that the person you're deposing has information about the matter that you've sued on. Yeah, there's a lot of legal words and we can peel that back, but that's fundamentally what this is about. And if not, those people in those positions ought not to have to sit for a 7-hour deposition that's taking them away from their real job. And lawyers that do plaintiff's work, and I do plaintiff's work sometimes, ought not to have to be able, or ought not to be able, to compel them to sit for a deposition just because I know if I can harass him enough or her enough, maybe they're just going to decide to pay money. That's fundamentally what this is about. And unfortunately, I think what we're left with was 74 as it came over. And as the senator from the 31st spoke to, the bill that you've got to vote on, 74, doesn't help the fundamental inequity and unfairness of what I just described. And that's what the senator from the 46 has tried to do. And I don't have any reason to believe anybody wants to waste any more time on this, but if you do wonder, go back and look at the regulated industries discussion that was had with the House member that came over and presented this, where the words unique and whatever the other words were debated for about 30 minutes. It got nonsensical. So who's really trying to be fair here and come up with a common sense yardstick by which we judge when people that are in charge of organizations ought to have to sit? And I think the bill that was worked on did. Unfortunately, this one does not. And that's what I don't want us to lose sight of, because that's why we're here. That's the problem we're trying to fix, and this one doesn't do that. I'm happy to answer any questions, Mr. President. Otherwise, I'll yield the well.
You do have one question, Senator. Senator from the 17th.
Senator Yield.
Sure, I'll be happy to.
Senator, sir, are you opposed to passing Senate Bill 74 as passed in the House?
As I understand the Bill 74, which this was not my bill, and I didn't spend the time, probably not as much as you did, Mr. Chairman. But as I understand, I think the author, I think the senator from the 46 and the senator from the 31st spoke to why this bill doesn't accomplish what's needed to have a functioning, balanced Apex Doctrine under Georgia law.
Would you further yield?
Sure.
Wouldn't you agree that the language in this bill is something that we know there's support for on the other side of this building, and that the language that was presented a minute ago is obviously not supported by this body at this time and does not have support across the other side of the building as well?
The problem, Senator, is that just because we know that they're going to support something on the other side, if it doesn't in fact address the problem, if it isn't a fair approach to a solution, that's no reason to vote on something in this chamber just because we know that they'll pass it.
Do you further yield?
Sure.
So it's your position that the language we have in front of us with this bill, even though it has everything that you were just speaking of, with the exception of the two words unique and you would rather not support this and have nothing at all?
Senator, that's a mischaracterization. This does not have everything in it that I would want to have in a bill. But this is not my bill. I'm not the sponsor of this, and so I can't speak to the details of that. But I will tell you that I don't think this bill, as presented for us to vote on, in totality, does what an Apex policy doctrine ought to have in it.
Do you further yield?
Sure.
Wouldn't it be better to pass a compromise bill that I think no one really loves, but at least puts the apex doctrine in our code versus passing nothing at all.
Except for this, the problem and the concern is that this bill actually can take us backwards, because if it creates a paradigm where this is your only recourse and you don't have the other recourses that are normally available under the Civil Practice Act, no. And that's the difference. Thank you. Mr. President, I yield the well.
Okay. Senators yielded the well. Would you like to speak, Senator?
Parliamentary inquiry.
State your inquiry.
Is it not true? I was going to ask the senator from the 18th. At the end of the day, is it not true that this is all about politics and making a bill look like maybe something it's totally not, such as just putting lipstick on a pig so somebody can get a political win out in the hallway?
Senator is passionate about what he speaks. Senator, would you like to close?
Thank you, Mr. President. I know it's kind of gotten silly at this point, but I don't think this topic's silly. We heard a couple of things just now about having to sit in federal court for depositions. Well, the Civil Practice Act doesn't apply to federal court. Doesn't matter. What this bill actually says is that if you are a high-ranking official in a government entity or any other public or private organization, you can say and try to show good cause for why you shouldn't be deposed by saying you lack unique personal knowledge on the subject matter involved in the pending action. After that happens, they've said the plaintiff's attorney, but I guess it could work both ways. The plaintiff's attorney, though, then gets to say, no, I've gone every other place I can to find this information, and you're the only one that has it, and you actually are the one that has it. Now I can depose you. How is that not sensible? This is the middle ground. I'd ask you to vote green, close this issue completely. It does not have to go back across the hall, and we can debate the next issue. Thank you, Mr. President. I yield the will.
Senator has yielded. Senator from 46, would you like to speak?
No, I had a question, but he yielded.
Senator has closed the debate. Question is on the SB 74. The senator for the 19th has moved that we agree to the House substitute. We've had lots of debate on this already, so I think it's time to vote on the underlying issue. Those who are in favor of the senator from the 19th position will vote yea. Those who are opposed, nay. Secretary, unlock the machine. On the motion, the yeas are 44 and the nays are 12, and this motion has prevailed. Moving on to recognize the senator from the 20th.
Thank you, Mr. President. I ask for unanimous consent to remove Senate Bill 106 from the table.
Senator has asked that Senate Bill 106 be removed from the table. Secretary, read the caption. Senator, let me correct you on your motion. You need to make a motion to agree, not move from the table. So,
Thank you, Mr. President. I apologize. I move that the Senate agree to the House substitute to Senate Bill 106.
Senator has moved that we agree to the House substitute on Senate Bill 106. Secretary, read the caption.
Senate Bill 106, a bill to be entitled an act to amend Article 7 of Chapter 4 of Title 49 of the Official Code of Georgia annotated, relating to medical assistance generally, so as to provide for a 3-year pilot program to provide coverage for remote maternal health clinical services under the Medicaid program, to provide for eligibility, to provide for a final report, to provide for termination of the pilot project and automatic repeal of the statute. The House offers the following substitute to Senate Bill 106, a bill to be entitled an act to amend Chapter 2A of Title 31 of the Official Code of Georgia annotated, relating to the Department of Public Health, so as to provide for a pilot program for home visiting in at-risk and underserved rural communities during pregnancy and early childhood to improve birth outcomes. That completes the order, Mr. President.
Recognize the senator from the 20th to speak to the motion.
Thank you, Mr. President. Earlier in the session, I came down here and we talked about our ranking in the nation as far as maternal and infant mortality and our lack of OBGYNs in many of our counties. And we wanted to try to address that with some inexpensive remote monitoring, such as a non-stress test. You all supported that measure virtually unanimously. It might have been unanimous. I can't remember, but strong support for that. The bill crossed over, and in the meantime, I had an opportunity to continue working with the Department of Community Health, and they asked me to change some of the language. It would still accomplish exactly what our intention was. And then I was also met with the Department of Public Health, and they wanted to partner with us on this bill to do some home visits in rural communities with pregnant mothers, and they would be able to then train the mothers on how to use this equipment and how to access the telehealth. So it was good timing. They were already looking into doing that, so we're going to have a real good effort to pilot this program and see if we can't get improved results with some telehealth, telemedicine opportunities to help our mothers and have healthy babies. I'd be happy to answer any questions if there are any, Mr. President.
You have no questions, Senator.
All right, I ask for you to agree with me on the House substitute. Thank you very much.
Does any other senator wish to speak for or against the measure? The senator has made a motion that the Senate agree to the House's position on Senate Bill 106. Is there objection? Without objection, all those in favor of the measure vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 28th, be on ready. On the passage of the motion, the yeas are 53 and the nays are 1, and this motion has prevailed. Recognize the senator from the 28th.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 215.
The senator has moved that the Senate agree to House substitute to SB 215. Secretary, read the caption.
Senate Bill 215, a bill to be entitled an act to amend Article 4 of Chapter 18 of Title 50 of the Official Code of Georgia Annotated, relating to inspection of public records so as to protect from public disclosure certain personal information of public employees. The House offers the following substitute to Senate Bill 215. A bill to be entitled an act to amend Article 4 of Chapter 18 of Title 50 of the Official Code of Georgia Annotated, relating to inspection of public records so as to require local governments to remove upon request certain personally identifiable information of law enforcement officers from certain property records. That completes the order, Mr. President.
Recognize the senator from the 28th.
Thank you, Mr. President. I bring y'all SB 215. This bill we've done actually a couple years in a row now, and it's dealing with public disclosure and government employees being able to remove their names from a public website to where they can't be harassed should they choose. The House has made a few changes to make it a little more narrowly tailored towards law enforcement on when we're talking specifically about the websites, and that's all it does. So this bill has passed both chambers pretty handedly, but a lot of that's because of the vice chairman over in the House carried the bill and put his full weight behind it, and so I appreciate all his good work on this. With that, I'll yield for questions.
You have one question, Senator. Senator from the 14th.
Thank you, Mr. President. Senator Yield.
Of course.
Mr. Chairman, isn't that true that once this bill got to the House, Georgia First Amendment Foundation, some other open records advocates got involved and were able to work out a suitable compromise that this body should have no issue with whatsoever?
I believe that's accurate. I was not involved in those conversations. I think I was too low-ranking around here to be invited, but after seeing the final version, I'm in full support.
I hope you can find some more influence, Mr. Chairman. Thank you.
Thank you.
You have no questions, Senator.
Thank you. I yield the well.
Senator Yield, is there objection to the senator's motion on agreeing to the House substitute on Senate Bill 215? Is there objection? Without objection, those in favor vote yea. Those opposed, nay. Secretary, unlock the machine. We got one more measure. It's a pretty important measure we're going to do next, and then we're going to break for dinner, and then reassess how we're going to go from there. Senator from the 26th, I know you're ready to get to Macon, Georgia. On the passage of the motion, the yeas are 53, the nays are 1. This motion has prevailed. I want to recognize the senator from the 56th for a motion.
Thank you, Mr. President. I'd ask unanimous consent to remove House Bill 188 from the table.
The senator has asked that Senate Bill 188 be removed from the table. Secretary, read the caption.
House Bill 188, a bill to be entitled an act to amend Article 2 of Chapter 6 of Title 5 of the Official Code of Georgia Annotated, relating to appellate practice so as to revise the name of the Sexual Offender Registration Review Board. The Committee of the Senate on Public Safety recommends that this bill do pass by substitute, respectfully submitted by Senator Albers of the 56th District Chairman. Senate Public Safety Committee offers the following substitute to House Bill 188, a bill to be entitled an act to amend Article 2 of Chapter 6 of Title 5 of the Official Code of Georgia Annotating, relating to appellate practice, so as to enact Merriam's Law, to revise the name of the Sexual Offender Registration Review Board, to amend Title 16 of the Official Code of Georgia Annotated relating to crimes and offenses, so as to provide a definition, to provide that punishment for certain sexual offenses shall be life imprisonment. Senator Albers of the 56th and others offers the following amendment. Amend the Senate Committee on Public Safety substitute to House Bill 188 to replace lines 13 through 18 with the following. Name of the Sexual Offender Registration Review Board, to revise definitions, to require to location tracking for certain sexual offenders, to provide procedure for removal of such requirement, to repeal and reenact a code section relative to risk assessment, classification as sexually dangerous predator, and electronic monitoring. That completes the order, Mr. President.
Recognize the senator from the 56th to speak to the bill. I'm assuming there's no objection to taking it off the table. Hearing none, senator from 56, you got the well.
Thank you, Mr. President. I have served in this Senate chamber for quite some time now. Less than some of you, but more than most of you. And in only a few occasions can I tell you that we're going to do something that's so meaningful and so powerful to honor someone, their memory and their legacy, as well as the great work that has been done by their family. House Bill 188 is known as Merriam's Law, and its legislation ensure that Georgians are protected from our most dangerous sexual predators. The need for this legislation originates from the 2019 Supreme Court decision, Park v. State, that ruled it unconstitutional for sheriffs to continue monitoring dangerous sexual predators after they completed their probation sentences. Following this decision, this body studied the issue with a Senate Study Committee on Protection from Sexual Predators. And many of you made recommendations that became a part of this very bill. Since that time, both myself, Representative Saines, and so many others got connected with the family, who has a deep personal interest in this policy change and why it was made into Merriam's Law. You see, in 2021, Merriam, a 27-year-old woman, was kidnapped from her doorsteps after returning home from work right here in Atlanta and was murdered. The murderer, who is currently awaiting trial for her death, had multiple prior sexual felonies, including attempted rape of a minor. I want to take a moment to recognize Merriam's brother, Ali, and her best friend, Irene, and all their friends and supporters that are right up here in our gallery today. You have done amazing work through your advocacy and honoring her memory. Without question, Merriam is looking down from heaven right now, smiling at both of you. I want to thank our Lieutenant Governor and his staff for assisting us with this bill and helping make it a priority for our Senate and our House. Through the advocacy work that Merriam's case, the family learned about the gap in state policy, and they specifically went out to solve the problem. This individual should have been known, should have been leveled and monitored as a sexually dangerous predator, as determined by the Sexual Offender Registration Review Board, also known as SORB. However, that risk assessment never occurred due to SORB's large backlog and funding constraints. I want to thank SORB, as they have been instrumental in helping us craft this language in support of the bill, along with the Sheriff's Association, other law enforcement groups, and the Prosecuting Attorneys Council. Let me give you the bill's highlights. This bill changes the name of the Sexual Offender Registry, SORB, to the Sexual Offender Risk Review Board. This bill provides updates to 13 sexual felony offenses: rape, child molestation, and sexual battery, just to name a few. This bill provides an individual who is conceived or convicted of 2 of these felony offenses will serve life in prison or a split sentence to serve the remainder of time on probation and monitored by the state actively. The bill grants an offender, after 10 years on probation, the ability to go back before a judge for additional judicial review. And the bill has provisions related to SORB, allowing them to monitor these dangerous sexual predators and offenders who have had at least 2 felony convictions and will be monitored by the Department of Community Supervision until their official leveling process is completed. This bill grants an appeal process for individuals who can't show their leveling is not accurate, and therefore you have a floor amendment that makes it abundantly clear what that process is today. The floor amendment simply gives that appeal process for those dangerous sexual predators codified into this bill. My fellow senators, to the family, to the friends, to everybody who has been involved in this, I'm going to ask you to light this board up green today. Let's lock arms. Let's honor the life and legacy of Miriam. Let's make sure this never happens again. And Godspeed to her in heaven. I yield the well.
Thank you, Senator. Recognize the senator from the 14th to speak to the measure.
Thank you, Mr. President. I rise in support of the bill. I want to give my condolences to the family and to honor the work that they've done to try to make sure that that story never happens again. I want to be candid with y'all. I have voted against previous versions of this bill that were more expansive for the last few years in the House, and actually became a campaign issue, you can imagine, in one of my campaigns, because it's difficult to inject conscience in discussions about the criminal justice system. I want to thank the chairman and the sponsor of the bill for adding the appeal language. I think that creates a fair result with respect to being able to challenge classification. But just like I did previously today, and I'll be brief because I know we got dinner to get to, but I just want to drop a flag in the sand, because to be very clear about the way that this bill works, the issue is ankle monitoring. The issue is there's a few hundred Georgians who are convicted of previous sexual offenses that law enforcement and the governing authorities want to be able to put ankle monitors on. And the Supreme Court of Georgia said the reason you can't put the ankle monitors on past a sentence is because that's unconstitutional. It's a Fourth Amendment issue to put an ankle monitor on somebody for longer than their valid sentence. I have concerns always about using the criminal justice system and increased penalties as an administrative workaround to try to solve what is effectively an administrative monitoring problem. And I think we should just pause and recognize that this should be a green board today, but the thing that we are doing is we are making mandatory life sentences for people who are convicted twice of these offenses. And one of the offenses is statutory rape, 21-year-old and let's say a 15-year-old. Bad idea, really bad, don't do it. But if it happens twice, the judges don't even have discretion. It's a mandatory life sentence on that second offense. So, my philosophy with how we do work in here is if you're going to make a choice, own your choice. I'm voting green today because I think at the end of the day, we need some kind of a fix, but I'm not going to miss the opportunity to drop a flag in the sand and just say, we got to be careful when we use sentence exposure as a way to solve what are effectively administrative monitoring problems. And so with great respect for the sponsor, for the family, I think that we can support a measure in memory of somebody special, but also maintain that conscience about future bills that come up and how we use the criminal justice system with recognition, great gravity, and seriousness and understanding that these circumstances are very unique in this system. These are repeat offenders that I think, I understand why the sponsors brought the bill. So So I just wanted to add that note of conscience, and we'll see y'all in a little bit for dinner, but thanks, Mr. President.
Thank you, Senator. Senator's yielded well. Senator from the 34th, would you like to speak to the measure?
Thank you, Mr. President. Members of the Senate, I rise for a brief moment just to say I appreciate what the chairman has already said, and I had met the family, and the brother did share with me the story, and I was waiting to see if in fact you were going to carry it, but I told him that I would be honored to carry it, and I am so glad that we have this one before us today so we can do what's right for this young lady. Thank you, Mr. President. I'll yield the well.
Thank you, Senator. Does any senator wish to speak for or against the measure? Chair hears none. Is there objections to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on Amendment 1, authored by the senator from the 56, who has authored the bill as well. Is there objection to the amendment? Hearing none, Amendment 1 is adopted. The question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machines. On the passage of the bill, the yeas are 52 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. I want to recognize the family up there in the gallery. I do want to recognize the family in the gallery there, and I appreciate the senator for the 56 carrying that bill. They have patiently waited there for a long period of time. Our many condolences for your loss, and but also well done and making sure this measure saw its way through. So for that, thoughts and prayers are with you, and bless y'all for doing everything you did here. So thank y'all. Thank you, Senator, too, for that. Senator from the 33rd, for what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Is it true that the senator from the 36 accidentally hit the wrong button?
Senator, I have no idea what you're referring to, but I do know dinner is about to be served, so we're going to stand in recess for a second, or for a few, probably for the next hour, let's say about 7. We'll say about 7:30, 7:40, but we have dinner right here for the pro tem is provided. So we'll stand at ease and then we'll circle back. Thank you. Senate will come back to order. We've got some local House bills. We're going to read and assign them so they'll be available on Thursday. Secretary, read the caption.
House Bill 805 by Representative Mathis of the 149th, a bill
State and local government.
House Bill 806 by Representative Mathis of the 149th, a bill to be entitled an act to amend
State
an
and
act.
local government.
House Bill 807 by Representative Chiokas of the 151st, a bill to be entitled an act to create the Terrell County
State
Land
and
Bank.
local government.
That completes the order, Mr. President.
That's it. Report of the committee needs to be read by. All right. We also have a report of the committee, State and Local Government Committee. Secretary, read the committee.
Mr. President, the Senate Committee on State and Local Governmental Operations has had under consideration the following legislation and has instructed me to report the same back to the Senate with the following recommendation. House Bill 591, do pass. House Bill 593, do pass. House Bill 594, do pass. House Bill 700, do pass. House Bill 711, do pass. House Bill 728, do pass. House Bill 729, do pass. House Bill 730, do pass. House Bill 732, do pass. House Bill 733, do pass. House Bill 734, do pass. House Bill 737, do pass. House Bill 742, do pass. House Bill 743, do pass. House Bill 744, do pass. House Bill 748, do pass. House Bill 749, do pass. House Bill 750, do pass. House Bill 751, do pass. House Bill 752, do pass. House Bill 753, do pass. House Bill 754, do pass. House Bill 763, do pass. House Bill 764, do pass. House Bill 765, do pass. House Bill 766, do pass. House Bill 767, do pass. House Bill 768, do pass. House Bill 769, do pass. House Bill 770, do pass. House Bill 771, do pass. House Bill 773, do pass. House Bill 777, do pass. House Bill 785, do pass. House Bill 790, do pass. House Bill 791, do pass. House Bill 792, do pass. House Bill 802, do pass. Respectfully submitted, Senator Frank Ginn of the 47th District Chairman. That completes the order, Mr. President.
Senate has come back to order, and we're going to start pulling bills off the calendar, off the table here. So stand by. But Senator from the 23rd be on standby. You ready? Recognize the Senator from the 23rd for a motion.
Thank you, Mr. President. I ask that House Bill 230 be lifted from the table.
Senators move that House Bill 230 be taken from the table. Is there objection? Without objection, Senator, I recognize the Senator from the 23rd to speak to the measure. Secretary, read the caption.
House Bill 230, a bill to be entitled an act to amend Chapter 8 of Title 48 of the Official Code of Georgia Annotated, relating to sales and use taxes, so as to provide for a qualified consolidated government special purpose local option sales tax. The Committee of the Senate on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Huffstetler of the 52nd District Chairman. The Senate Finance Committee offers the following substitute to House Bill 230, a bill to be entitled an act to amend Chapter 8 of Title 48 of the Official Code of Georgia annotated, relating to sales and use taxes, so as to provide for a qualified consolidated government special purpose local option sales tax, to provide an exception to a ceiling on local sales and use taxes, to provide for definitions, to provide for authorization of tax and applicability. That completes the order, Mr. President.
Recognize the senator from the 23rd. Speak to the measure now.
Thank you, Mr. President. Colleagues, I bring you the Senate substitute to House Bill 230. House Bill 230 is a C-SPLOST measure, a consolidated government SPLOST. It is focused on Augusta-Richmond County. It would authorize a referendum by the voters to determine whether or not citizens should assess themselves a half-penny SPLOST tax to fund the construction of a new coliseum and arena. The framework for this C-SPLOST mirrors the framework for SPLOST in other consolidated governments, and it applies specifically only to Richmond County. The arena is a regional facility where the only way to gain regional support is through a SPLOST measure. 40% of all funds would come from outside of Richmond County. Many of those funds would come from neighboring South Carolina. The project will be financed through revenue bonds. Conservative estimates suggest that the bonds can be issued for construction and approximately repaid in less than 20 years. The cap on the project is $250 million for construction, and the bill will sunset once the project is fully funded. This legislation is supported by the Augusta-Richmond County Chamber, the Augusta-Richmond County Commission, and the Augusta Coliseum Authority. Ladies and gentlemen, I ask your favorable consideration for Senate substitute to House Bill 230. I'll be happy to yield for questions or yield the well, Mr. President.
You don't have any questions, Senator.
Thank you, Mr. President. Yield the well.
Hold on, Senator. Hold on, Senator. We got recognize the senator from the 22nd. Not you, Senator. No, sir. No, sir. Recognize the senator from the 22nd to speak to the measure.
Thank you, Mr. President. I'll be brief. If you remember a couple of weeks ago, we talked about we had a process, and myself and Senator from 23rd kind of disagreed on something that we were going to go to the voters. Well, this isn't that case. This went through that process. All persons in Augusta basically are on board with this particular project. We all had give and take. We all talked about it, and we're 100% in favor of this measure. So we ask for your favorable support. And with that, I yield the well.
Recognize the senator from 56. Speak to the measure.
Thank you, Mr. President. I have great admiration and respect for my two colleagues here from the 23rd and 22nd. My concern is not the great work they're trying to promote for their area of the state. My concern is for the integrity of the SPLOST system, and I, along with many of us, have worked diligently on that over the last many years. This opens the door to the very thing we were afraid of what would happen with a SPLOST. We have a mechanism to do things today. City of Atlanta has most of the folks coming from the outside in, and they use hotel motel taxes as well as their existing tax base, and they bond things out in order to build them. Alpharetta, Georgia, which I represented for 12 years, does the exact same thing. In fact, they balloon from 60,000 people during the day to 2 to 3 times that when businesses come to town. My concern here is we are opening the door, and next year we'll have 158 new requests of everybody else who will find something in their community that more sales tax will have. That can certainly be beneficial, but if our goal as Republicans is to have the sales tax hopefully be used to lower the income tax, then that would be a much better place to do that. In this state, there is only one area that has a tax that is higher than everywhere else, and you're right here in Atlanta. It's at 8.9%, and there's only one reason for that. because of a federal lawsuit that we had to fix the sewer systems and put a separate special 1% sales tax on. So they would be at 7.9%. Augusta Richmond will be at 8 and now 8.5%, the highest in the state, minus the one that is trying to overcome a federal lawsuit. This will be to what end at one time? I would caution us that we have resisted every work on SPOST over the years to keep it true to what it was designed to do. We have eSPOST, we have T-SPOST, we have HOST, we have MOST, we have LOST. Now we have a C-SPOST. What's next? So again, I very much admire and appreciate, and if I was senator from the 23rd, 22nd, I would be advocating and do everything in the world I could for my home county and my home area, but we have to be careful. I yield the well. Thank you.
Senators yielded the well. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 43 and the nays are 11, and this bill, having received the requisite constitutional majority, therefore has passed by substitute. I recognize the senator from the 32nd for a motion.
Mr. President, I ask unanimous consent that Senate Rule 3-1.2A be suspended to allow for the first reading and assignment of a series of bills.
Senators move that, ask for unanimous consent on that Senate Rule 3-1.2A be suspended for the following reading and assigning of two separate bills. Secretary, read the bills. Is there objection to that? Chair hearing. Secretary, read the bills.
Senate Bill 330 by Senator Kirkpatrick of the 32nd and others. A bill to be entitled an act to amend Chapter 8 of Title 4 of the Official Code
Public Safety. What's the next one?
Senate Bill 331 by Robertson of the 29th and others. A bill to be entitled an act to amend Chapter 5 of Title 26 of the Official Code of Georgia annotated relating to drug abuse treatment and education programs, so as to provide for the certification of recovery.
Health and Human Services.
That completes the order, Mr. President.
Recognize the senator from the 20th. I think it's on HB 480, Senator.
Thank you, Mr. President, for waking me up. I asked for unanimous consent to remove the bill off the table.
Senator has moved that House Bill 480 be taken off the table. Is there objection? Without objection, Secretary, read the caption.
House Bill 480, a bill to be entitled an act to amend Chapter 9 of Title 34 of the Official Code of Georgia annotated, relating to workers' compensation so as to change certain provisions related to workers' compensation benefits, to change provisions relating to a surviving spouse, dependency determination, and termination, to increase the compensation benefits for total disability and temporary partial disability. The Committee of the Senate on Insurance and Labor recommends that this bill do pass. Respectfully submitted, Senator Walker of the 20th District Chairman. That completes the order, Mr. President.
Is there objection to moving it off the table? Hearing none, I recognize the senator from the 20th.
Thank you, Mr. President. Every couple of years, we customarily update our workers' comp statute. There's a workers' comp advisory council that includes members of industry, insurance companies, attorneys, and lay people, and they get together and make recommendations on what we need to do to update our system. The primary thing we have to do is keep our weekly benefit for total disability and for partial disability in line with the Consumer Price Index. And essentially that's what this is doing. This bill will increase the maximum allowable weekly benefit for an injured employee who suffers a temporary total disability from the current amount of $725 to $800, and that's the maximum weekly benefit. Doesn't mean everybody would qualify for that, but that's the maximum. And then it raises the benefit for a temporary partial disability from $483 a week to $533 a week. And further, the maximum total compensation payable to a surviving spouse as a sole dependent after the death of an employee will be increased from $290,000 to $320,000. Again, it's a customary update to our workers' comp statute. I'd be happy to answer any questions. If there are no questions, I will yield the well. Thank you.
You do have a question, Senator, but you always have the right to yield the well, whatever you want to do. You're such a masterful salesman, I'd just go and sell it.
Sell it? All right. I'd ask for your favorable consideration. Thank you.
I recognize the senator from the 27th. He's gone. Masterful job, Senator. Senator from the 27th, do you wish to speak?
Parliamentary inquiry, Mr. President.
State your inquiry.
Mr. President, is it true that I was going to ask the sponsor what the lines 40 through 45 mean, where it speaks to people living together in a relationship that is similar or akin to a marriage, and how that is related to the annual cleanup of this bill?
I have no reason not to believe that's what you're going to ask him, but you're going to have to ask him offline. So, does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 52, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed. I recognize the man from Perry, Georgia, for a motion.
Thank you, Mr. President. I ask for unanimous consent to remove House Bill 529 from the table.
The senators move that we remove House Bill 529 from the table. Secretary, read the caption.
House Bill 529, a bill to be entitled an act to amend Titles 33 and 40 of the Official Code of Georgia annotated, relating to insurance and motor vehicles and traffic, respectively, so as to provide for minimum amounts of uninsured and underinsured motorist coverage to be maintained by transportation network companies and taxi service companies. The Committee of the Senate on Transportation recommends that this bill do pass. Respectfully submitted, Senator Dolezal, the 27th District Chairman. That completes the order, Mr. President.
Is there objection to the motion from the senator from the 20th? Hearing none, I recognize the senator from the 20th to speak to the bill.
Thank you, Mr. President. Back, I don't know how many years ago, but when transportation network companies came into being, think Uber and Lyft, but they're transportation network companies. It was a new technology, a new concept. So there was some concern about making sure the riders were protected, and we required them to carry $1 million in uninsured and underinsured motorist coverage, not liability for something that the Uber driver or Lyft driver did, but liability for a third party that were to hit the car or cause some sort of injury to the passenger, not Uber or Lyft. This has proved to be quite costly for these companies, and of course they have to pass that cost on to the ridership. And they tell me that Georgia is one of the most expensive states in the country for transportation network companies because of this, and they've asked for some relief. To put it in perspective, our taxi cabs and our limousines are only required to carry $25,000 injury per person, $50,000 per accident of coverage, and that's in line with what our minimum state liability limits are. So it's not an unreasonable ask, but instead of going all the way to the state minimum, the compromise that was agreed to was to have a limits of $300,000. And that's what this bill does. Let me see if I can find it in the bill. All right, so on line 24, it strikes 1 million, and it says with minimum limits of 300,000 for bodily injury to or death of all persons in any one accident, with a maximum of $100,000 for bodily injuries to or death of one person and $25,000 for property damage. If you have any questions about that or how that coverage would work, I'd be happy to answer them. Or we could talk about matricious relationships.
You do have a question, Senator. It's Senator from the 46.
I don't know that this body wants to go there, really, but I'll be happy to yield for a question.
You do have a question. Senator from the 46.
Thank you, Mr. President. Senator Yield.
Yes, sir.
So are you reducing the liability coverages that Uber is required to provide in case their drivers hurt somebody?
No, sir. We're just reducing the uninsured motorist coverage. So it would not eliminate or reduce the liability that caused by their driver or by Uber, it would be from a third party.
What does the current law require
$1 million.
in uninsured motorists also?
Yes, sir.
Okay, thank you, Senator.
You have no further questions, Senator.
All right, I'd ask for your favorable.
Oh, well, actually, there was a late coming question if you got time for one more, Senator, but you're always welcome to yield the well. Senator from the 22nd.
I'll be glad to take a serious question.
It is. It's just, my question is, isn't it accurate that actually these reductions have been done nationwide and it's something that has been agreed upon and has been going on from different states, these reductions on the uninsured motorist coverage?
I'm sure the senator knows of which he speaks. Thank you very much. I'd ask for your favorable vote. Yield the well.
Senator has yielded the well. Any other senator wish to speak for or against the measure? Chair hearing none. Is there objection to the previous question being ordered? Chair hearing none, the previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none, the report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, the main question is ordered. The question is on the passage of the bill. All those in favor of the bill will vote yea, opposed nay. Secretary, unlock the machine. All in the passage of the bill, the yeas are 52 and the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Recognize Senator from the 56 for a motion.
Thank you, Mr. President. I'd ask that House Bill 437 be removed from the table.
Senator has moved that House Bill 437 be taken from the table. Is there objection? Without objection, Secretary, please read the caption.
House Bill 437, a bill to be entitled an act to amend Chapter 9 of Title 45 of the Official Code of Georgia annotated, relating to ensuring indemnification of public officers and employees, so as abolish the Georgia State Indemnification Commission and authorize the Commissioner of Administrative Services to assume the duties of said commission in the administration of the indemnification program and in considering appeals of initial decisions in order to correct errors. The Committee of the Senate on State and Local Governmental Operations recommends that this bill do pass. Respectfully submitted, Senator Ginn of the 47th District Chairman. That completes the order, Mr. President.
Recognize Senator from the 56 to speak to the measure.
Thank you, Mr. President. I'm glad after this great work and debate over the last few years, today we can implement remote online notary for the state of Georgia. Kidding. House Bill 437 might be the easiest and best bill we passed today. This actually eliminates part of government. We abolish a commission, move it to the department that will make sure that we have an efficient process to help out those in public safety who need to receive a death benefit to their family and add an extra appeal to the Superior Court. This is less government, improving our service, and I'd ask for your favorable consideration and yield if there are any questions.
You do have a question, Senator. Senator from the 28th.
Thank you, Mr. President. Senator, do you yield?
I yield for the very powerful Rules Chairman.
Senator, did this bill go through GORC?
We eliminated GORC, Senator, but thank you.
Oh, yeah, I forgot. Thank you.
And thank you for your good work on eliminating GORC.
You have no further questions.
Thank you,
Senator.
Mr. President.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agree to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 54, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. All right, we're going to move to some special agrees and disagrees here. So I recognize a senator from the 4th for motion.
Mr. President, I move that the Senate agree to a House substitute to Senate Bill 211.
The senator has moved that the Senate agree to a House substitute on Senate Bill 211. Secretary, read the caption.
Senate Bill 211, a bill to be entitled an act to amend Title 20 of the Official Code of Georgia annotated relating to education, so as to establish the Georgia Council on Literacy, to provide for consultation with subject matter experts, to provide for automatic repeal, to require local school systems to develop and implement 5-year literacy plans for such school system and individual literacy plans for students in kindergarten through grade 5. The House offers the following substitute to Senate Bill 211. A bill to be entitled an act to amend Title 20 of the Official Code of Georgia annotated relating to education, so as to establish the Georgia Council on Literacy, to provide for definitions, to provide for members and officers, to provide for meetings, agendas, quorum, and compensation, to provide for the council's duties and powers, to provide for consultation with subject matter experts. That completes the order, Mr. President.
Without objection, I recognize the senator from the 4th. Speak to the measure.
Mr. President, thank you. This is a small change that the House made to Senate Bill 211, and without going through it, I've agreed to it. We actually agreed to the change actually a couple of days ago. So, Mr. President, if no question, I yield a will.
You do have a question, Senator. Senator from the 18th.
Thank you, Mr. President. Does the senator yield?
Yes, sir.
Senator, I just want to congratulate you on the fine work that you've done. You really have led not only the caucus but this chamber on a very important issue with the state of Georgia, and it's entirely fitting and proper that we get this bill passed tonight. And is it not true that I completely support your bill?
Thank you, sir. It's a team effort, and we had a lot of great people working on this, and I've seen this everywhere. So thank you, sir.
Yes, sir. Thank you.
You have no further questions, Senator. Thank you. The senator has moved that we Senate agree to the House position on Senate Bill 211. Those there is no objection, so those who are in favor of this move will vote yea. Those opposed, nay. Secretary, unlock the machines. Well, we just had one holdout. On the passage of the motion, the yeas are 55 and the nays are 0, and then there's somebody not paying attention while they're standing at the desk. So, but that's all right. Let's give our good senator from the 4th a big round of applause here for champion literacy. This was you great job, Senator. Good job on your committee. Good job with your partnership with the chairman of K through 12 education. This was a priority for the Senate, and great work and great working with the House, and just really did a really good job. I know you make the folks in Statesboro, Georgia, proud of you. So we appreciate that, Senator. Very good, very good. Recognize the senator from the 13th for senator from the 13th for a motion. Yep.
Thank you, Mr. President. I move that the Senate agree to the House substitute of Senate Bill 62.
The senator has moved. I'd like to recognize the senator from the 41st. What purpose do you rise?
Mr. President, I move that we agree to the House as amended.
Ooh. Well, I've already taken his amendment, but you are in order, I guess. So yes, you are right. Okay. So Secretary, read the caption.
Senate Bill 62, a bill to be entitled an act to amend Chapter 60 of Title 36 of the Official Code of Georgia Annotated, relating to general provisions applicable to counties and municipal corporations, so as to prohibit certain local ordinances or policies relating to public camping or sleeping. The House offers the following substitute to Senate Bill 62, a bill to be entitled an act to amend Titles 31, 36, and 50 of the Official Code of Georgia Annotated, relating to health, local government, and state government, respectively, so as to prohibit hospitals, local governments, and local authorities from dropping off homeless individuals in counties other than such persons' county of residency or the area of operation or jurisdiction of the hospital, local government, or local authority, to provide for exceptions, to provide for liability, to prohibit certain local ordinances or policies relating to public camping or sleeping. That completes the order, Mr. President. Senators Jackson of the 41st and others offered the following amendment 1 to amend the House Committee substitute to Senate Bill 62 by striking lines 1 through 90. That completes the order, Mr. President.
I recognize the senator from the 41st to speak to the measure.
Thank you, Mr. President. I rise to ask that you all would support my motion to amend. Let me give you a reminder. We had this bill in the Senate, and we worked on perfecting it together by making some amendments in the first place. So this bill has to do with homelessness and how we legislate how counties and municipalities deal with the issue of homelessness. We had a long and robust conversation in this body already where we came to a place where lawyers educated us about the term writ of mandamus. Do y'all remember that? I still don't know what it means, but it's not a good word because we got rid of that word. We also got rid of a whole lot of other things until what we had left together as a body was for all federal funds and all dollars related to homelessness for them to be audited. That's where we landed in this body with SB 62, and so I'm simply asking that we go back to that same place where we take time to have a full audit of how these monies are used, and that we also make sure that we get rid of this writ of mandamus where any person can come and sue and we have to pay their fees as they sue. So again, this is fundamentally about returning to the work that we did as a body by calling for an audit and not introducing additional burdens on our cities and our counties as it relates to homelessness. I will take questions if there are any.
You have no questions, Senator. I recognize the senator from the 14th to speak to the measure.
Thank you, Mr. President. Massive shocker. I support the amendment. And I think the thing, the theme we keep talking about with criminal legal system is tightening the screws, turning up the heat in order to solve problems. This is related. This is a similar type of measure in the sense that it turns the screws on local governments to try to solve a problem that is so layered, multifaceted, and complex that this type of hammer just doesn't do what we would like for it to do. I mean, I echo the senator from the 41st in commending, the intentions and the purpose of a bill like this, which is try to attack a really difficult problem. But I mean, right now I'm going to more forcefully call for pause than I did on the last bill before dinner for a lot of reasons. But I mean, one of them is, what are local governments going to do in a situation like this? Obviously, it has to be a written policy, and so they would have to have a written policy of, prohibiting the enforcement of an order, and that, may be rare, but local governments oftentimes do lack the political will to take firm action on issues like this because of how divisive they are. And by forcing their hand, we don't make the problem any easier to solve. So, I'm starting to repeat myself, but I guess the real issue I've got is, some of these policy debates are not amenable to bite-sized discussions like these on an individual bill with individual considerations and language. This really is a discussion that's much broader, that has to do with investment in communities on all the different policy fronts we talk about, healthcare, education, et cetera. And I know we're impatient. I know that we don't think that those interventions work quickly enough, and we would like for them to work faster. But when they don't work fast enough for us, we can't turn to knee-jerk solutions that, again, force local governments to move deck chairs around and not be able to really address the problem. So I apologize if I sound kind of frustrated. I think it's just, with the late hour and moving on something like this, I think it feels good to say we're doing something, but I don't think this is going to do what we want it to do. So I would respectfully ask that you vote yes to the amendment and no on the underlying bill if the amendment doesn't pass. I would yield for questions, Mr. President.
You do have a question, Senator. Senator from the 30th.
Thank you, Mr. President. Will the senator yield for just two simple questions?
I would, Senator.
When you say pause, are you talking about the pause like we did last year in this session where we did a study committee over the summer to come up with the legislation that you see before you?
Well, I think the senator is well aware that I wasn't here, and so...
I'm talking about the body, Senator.
Right, absolutely. So what I mean by that is, obviously, I don't have direct experience with the actions that the Senate may have taken. But no, when I say pause, I mean longer than a year and longer than a study committee. Because again, these types of issues are so intractable and they're so widespread. I mean, a lot of ways you can think of homelessness or many of the other ills that we have as symptoms of underlying conditions, right? We have an apathy towards our neighbors, right? We have an unwillingness to live in proximity to our neighbors, not just people who experience homelessness, but maybe people who live in a different type of housing than we're used to, right? I mean, we hear the phrase NIMBY a lot. And so I think, when I say pause, what I mean by that rhetorically is before we rush to, implement policy that's just going to turn the screws, turn up the heat on governments that don't have easy solutions to this, let's take a step back and really think about how layered and complex these problems are and find the political will to make the tough investments across the board.
Thank you, Senator. Those were exactly the points that were discussed last year during the study committee. The second question I have for you is, you said it's not solving the problem. In your mind, is what we're doing right now to address the problem working?
No, but I mean, there's an analogy I like to use a lot in public
Thank you,
policy context, and that is the idea of, let's say a house is on fire, and you want to put the fire out on the house, but you can't find any water around. All you've got is a big tub of gasoline. It wouldn't make any sense to say, well, the only thing we've got to throw on this fire is gasoline. We got to throw something, so let's throw this, right? And the reason I like that metaphor is because that is the way we think a lot about public policy problems that are really tough. And we tell ourselves there's not water available to put out the fire. But it just takes, I think, some patience and some recognition that these problems do not get solved overnight and require real faith in our neighbors and investments in community that, again, may fall on partisan lines sometimes, but are deeply and fundamentally about believing in our neighbors.
You do have a couple more questions, Senator. Senator from the 41st.
Senator, you yield?
I do.
Senator, isn't it true that we did have a bipartisan study committee on homelessness over the summer on which I was a participant in?
I believe that is true.
And Senator, isn't it further true that in our bipartisan, deeply well-studied study committee, the only thing that we could all actually agree on was the need to study where is the money going, because we heard from all these different organizations that are funded from philanthropy money and federal dollars, and the one thing, isn't it true, sir, that we could agree was that we needed to do a full audit to understand where the money was going.
Senator, given my understanding of the Venn diagram of Georgia politics, I would imagine that that is that center space that you're talking about. And I think that, that is in line with the idea of pausing to make sure we understand what we're doing with the money we're already spending, but before we resort to tactics that the local governments don't want, that only maybe one party in this chamber agrees with, and won't fundamentally get at the root of the problem.
Do you further yield?
I do.
I believe it's also true, isn't it true, Senator, that in that whole many meetings and hours long study committee that we never had any discussion about hospitals dropping off patients, and yet this bill suddenly is talking about hospitals dropping off patients who are homeless? Isn't it true that that was not a part of our hours and hours long study committee?
If the senator states it to be true, and one thing I would say is that, I think part of the description of this bill is going to be, oh, but we're prohibiting drop-off. This is an anti-drop-off provision. Not if you fall under one of the unless provisions right under it, right? And so what this bill would do is legitimize a system of drop-off under certain conditions that local governments could justify. I mean, there are real false imprisonment issues and Fourth Amendment seizure issues that go into transporting human beings. And I think for us to move on that and to facilitate a legal type of forced transportation by local governments is a dangerous step if we don't all agree on it, Senator.
Senator from 36.
Thank you, Mr. President. Senator Yield.
I do.
Thank you for your remarks. And essentially, as I understand it, your point is, and the thrust of the amendment, which I support, is that on page 5, section 4 calls for an intensive data gathering and audit of spending on homeless programs and services statewide. It's true that doesn't occur overnight, isn't that the case? Really taking a deep dive and getting information from all the sources that are out there was the core recommendation of the study committee and should be at the heart of this bill as opposed to these other things that have been added. Isn't that true?
Absolutely, Senator. I think it's the obvious first step, and I think, again, given how layered and complex the issue is, this is particularly one where you don't want to jump in, head first.
Additionally, if I could further question, we are in the process in the second year of addressing mental health parity. It's widely documented that many of the unhoused people that have no roof over their heads are struggling with mental health issues or substance disorder issues. Isn't that the case? And that we are in the midst of a process that we firmly hope is going to have positive outcomes for services for people struggling with mental illness and as well as substance abuse disorder. Isn't that the case?
Senator, that's absolutely right. And I think it speaks to this broader theme, which is you don't solve a problem by putting it out of view. And I know that some proponents of the bill will say, well, no, we're banning that. But not if you fall under one of the legal exceptions. This is, in essence, a superficial response to homelessness that doesn't do the hard work of getting to know our neighbors, of investing them, and waiting until we have the information we need to know how to treat our neighbors humanely.
Thank you for that. And further question, this very body has supported robustly, both parties, co-responder model, where people are approached not with a law and order heavy beatdowns, but instead a law enforcement is accompanied by or substituted in some cases with a mental health professional. Isn't that the case? And that this is a new step that we're modeling for some very successful efforts in some counties. Isn't that right?
It is, Senator.
And that we are still hoping to build that out statewide. Isn't that the case? And yet again, another positive approach that people have united around to address the issues facing our homeless population and facing the municipalities and counties as well that are seeking to struggle with this problem.
It is, Senator. And the last thing I'll say in response is what we know is that good policy that is carefully crafted by a bunch of stakeholders is very delicate. It's a very delicate compromise that has a hard time getting into rooms like this and surviving. Because in a room like this, we're driven by what? The need to give voters results, outcomes, results. Look what we did. We took action. And complex problems like this, not always susceptible to that type of politics.
Thank you for that response. And finally, many of us are planning to go to the opening this week of a center just here very adjacent to the Capitol, the Police Alternative Diversion project. That's not a project any longer. It's a building out program that demonstrates success and merits more funding. And that's going to be available to people just Thursday afternoon at 4 o'clock right here in our neighborhood. If you want to learn more about how these alternative approaches are working, and is one more good reason in the case that we should stick with this language on line 92 to 104 and move forward in a positive
That's right.
direction.
And while acknowledging that the bill makes some accommodation for diversion, I think what we don't want to do is turn the screws up in every case that doesn't fall under some carefully limited exception. You know, to use what the kids would say on TikTok, let them cook. You know, let them finish the projects that we're already starting and see where those go.
Thank you, Senator.
Thank you. If there are no other questions, I'll yield the ball.
You have no further questions, Senator. Senator from the 13th.
Thank you, Mr. President. Colleagues, here we are talking about homeless again. Actually, we spent more than last year talking about homeless. We spent about the last 2.5 years talking about homeless. And since I came into this Senate body, I've counted the homeless population go up between my little ride from where I live when I'm in Atlanta to this Capitol daily and nightly. I can take you right now and take you out to the bridge out here where the Coca-Cola Museum is, and I'll promise you, if you're not looking where you're going and you run over the curb, which is only about 4 inches high, you'll take out anywhere between 15 and 20 people before you can stop your car. It grows all the time. Every person we interviewed, every person that came in our study committee said, homeless is getting worse and worse and worse. It was not getting better. We all know that. This bill attempted to make a difference about homeless in Georgia, not Atlanta. Nothing is indigenous to Atlanta. We're talking about Georgia. Now, there's this little part that was added over in the House. We sat and we debated it over in the House, and I worked with the representatives that added the part on there. And I personally think it's a great add-on, because what was going on was, I will not call out law enforcement. I will not call out ambulances. I will not call out these different government outfits. But they were picking up homeless, and they were taking them to, like, for example, in Athens, Clarke County, because they have a facility to handle them, they were dropping them off there from other counties. And that's not right. Each county must deal with homeless. Each county has to have a plan to deal with homeless. And what we're doing is we're forcing a county to differently deal with homeless and make sure they know that they're going to get the funding, which the audit should tell us where the monies are, what's going to be done for homeless. And that's the problem, folks. None of us in this Capitol have a clue how much money is out there in homeless. None of us. We're talking 10 million and we're talking 200 million. We don't know. We don't know how many 501(c)(3)s are out there. We don't know what they're doing with the money. We hope they're helping. I want to think they're helping. But the reality of it is, folks, we can do better. We can do better. And the law, what we decided when it was debated in this chamber, we took out the Q-Town action and we added the mandamus action from the senator from the 6th over here. He added the mandamus action in, which I agreed to. And I agreed to because I am not a lawyer. I'm just trying to make a problem. I'm trying to deal with a problem and hopefully find a way to make it better. So I would tell you up front, we added a part about local governments in the audit now have to participate in the audit because it was brought to our attention over there that we were only dealing with federal monies. So now we made it that all areas all encompassing has to deal with the audit, and everybody must comply with the audit. So we find out that all the monies that are there, not just some, all the monies that are sitting out there. So I would ask you that you not vote for the amendment. Let's move this good bill forward, folks. God almighty, let's do something about homeless. I live in Cordell, Georgia. I'm 145 miles from here. We have a little bit of homeless problem, nothing like we got in these big cities up here. You want to make a difference? Make a difference. Vote for this good bill and do something about homeless. And let's quit arguing about how we're doing it and quit worrying about these party line crap. Vote, let's do something with homeless and get on with it. Because you got a good bill here. You got a bill that protects people, that's not allowed to haul them off and just drop them off somewhere like they're a piece of garbage. And it's going to find out where they're going. It's going to find out have an audit trail and find out where they're going. And last but not least, folks, we might actually make a difference. We might actually make a difference. Please turn down the amendment. Let's vote for House Bill, the Senate Substitute 62. I yield the will, Mr. President.
All right. Senator from the 41st, would you like to close debate?
Thank you, Mr. President. I'm actually really grateful to be able to follow the senator from the 13th because we agree with each other about the thing that he was most passionate about, which is that we need to audit. We need to do a full and complete audit of where the money goes, who has the money, and is the money being used well? If you notice it from his body language, that was the thing he got most excited about, most activated about. It's the audit. And that's exactly what my amendment does. It leaves the audit intact. And so I strongly encourage you, let's be deliberative. Let's return to the very place where we started. Because remember, when we passed this bill out of the Senate, all it called for was an audit because we wanted to know where the money comes from. I will tell you, I was in that study committee, and the only thing we could agree about in a bipartisan way was that we need to audit the money. Because once we have a full audit, then we can make some calculated and important choices and decisions about how to best use that money. Until then, we just need to hold on and allow the people who are out in the hallways and who are out across the street and who are doing the work every day with people who are experiencing homelessness, who are doing their best to get people into housing. We need to let them continue to do that work while we do the audit. And then when we have the audit, we can make different choices if they are called for. So I do urge you, please vote yes on my amendment. I'm going to agree as amended. Thank you.
All right, senators yielded the well. Does any other senator wish to speak for or against the measure? Chair hearing none. Here's the posture that we're in right now. Because senator from the 41st, the underlying bill was the senator from the 13th, but the senator from the 41st moved that the Senate agree to the House substitute as amended. It's a similar posture that we had earlier in the day here. So what we're going to do is we're going to vote for the senator from the 41st Amendment. Those who are in favor of her amendment will vote yea. Those who oppose, nay. And Secretary, unlock the machine. On the motion from the senator from the 41st, the yeas are 22 and the nays are 32, and this motion has failed. Now, moving on to the senator from the 13th motion, where he, make your motion once again, senator from the 13th, so we're clear on it.
Mr. President, I move that the Senate agree to the House substitute to Senate Bill 62.
Senator has moved that the Senate agree to the substitute on Senate Bill 62. Would you like to speak, Senator?
Green.
All right. Is there objection to the motion? You object? All right. All those in favor of the motion will vote yea. All those opposed, nay. Secretary, unlock the machine. On the passage of the motion, the yeas are 36 and the nays are 20. And I'm going to call on Miss Lily Watson, the senator from the 11th, daughter right here, who's here. And why don't you bang the gavel right there, Lily? All right. We have Miss Emily, Sam's wife, here with us, the first lady of the 11th district right there. So they're in town. Glad to have them here today. Glad to have Lily here. And you about ready to go on spring break, aren't you? All right, good. Well, hopefully we'll be on spring break with you too. So thank you so much, Lily. Also, before we move on, I want to recognize we've got one page that's left. Buttercup Simons. It's Buttercup. There she is. All right. All right. Good job. Good job. So, yay. All right. She's working hard today. She's the last one we have left. So thank you so much. Thank you so much. All right, moving on. We've got Senate Bill 159. I recognize the senator from the 29th.
Mr. President, I move that the Senate disagree to the House substitute to SB 159.
Senators move that the Senate disagree to the House substitute of SB 159. Secretary, read the caption.
Senate Bill 159, a bill to be entitled an act to amend Article 1 of Chapter 5 of Title 42 of the Official Code of Georgia annotated, relating to general provisions regarding correctional institutions of states and counties so as to prohibit wireless communications and standalone electronic devices behind guard lines. The House offers the following substitute to Senate Bill 159, a bill to be entitled an act to amend Article 1 of Chapter 5 of Title 42 of the Official Code of Georgia annotated, relating to general provisions regarding correctional institutions of state and counties so as to revise punishment provisions relative to prohibited items in possession by inmates. That completes the order, Mr. President.
Senate has moved to disagree to the House substitute. Senator, would you like to speak on, you're good? Any objection? Without objection? We don't have to vote. Without objection, we will send it back over. Send it back to the House. I recognize the senator from the 29th again, Senate Bill 92.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 92.
Senator has moved that Senate agree to the House substitute on SB 92. Secretary, read the caption.
Senate Bill 92, a bill to be entitled an act to amend Article 1 of Chapter 18 of Title 15 of the Official Code of Georgia Annotated, relating to general provisions regarding prosecuting attorneys, so as to create the Prosecuting Attorneys Oversight Commission. The House offers the following substitute to Senate Bill 92, a bill to be entitled an act to amend Chapter 18 of Title 15 of the Official Code of Georgia Annotated, relating to prosecuting attorneys, so as to provide for duties of district attorneys, to create the Prosecuting Attorneys Qualifications Commission, to provide for definitions, to provide for the... That completes the order, Mr. President.
Is there objection to the motion? Without objection, I'll call on the senator of the 29th to speak to the measure.
Thank you, Mr. President. Colleagues, we're all familiar with this piece of legislation. We sent it over. We went through the committee process through the House as it should have done. We worked hard on this legislation. I want to recognize my good friend, Representative Gullett, who has been working on this legislation with me for 3 years now. And the additions that were made through this process was an appeal process to the Superior Court judge within the circuit where the DA is practicing and is elected, and also added was additions to point out the opportunity that if a judicial circuit district attorney fails to perform their duties provided under Code Section 1518.6, or solicitor fails to do their duty under 1518.66, that it shall constitute grounds for recall of that individual. What they have done is they have taken an excellent piece of legislation and they have made it better. And I ask that all of my colleagues vote green on this so that we can close this gap within the criminal justice system and move forward with making Georgia the safest state to live in the United States of America. Thank you so much, and I look forward to your green vote. Mr. President, I yield the well.
Senator yielded the well. I recognize the senator from the 42nd. You. You don't have to say anything, Senator, if you don't want to.
Thank you, Mr. President. This is a huge sea change in the law as it stood for hundreds of years, here in Georgia. So I just wanted to go back over some of the very incisive and important arguments that those against this particular piece of legislation make when we're talking about an attack on a duly elected district attorneys throughout our state of Georgia who serve the people who have elected them. DAs are elected officials and are accountable to the people and the community that they serve. That's who elected them. Stripping local DAs of the autonomy to make decisions around the safety and well-being of their local community erodes the rights of those local residents and the voters to choose the leader that best reflects and furthers their vision for the justice system in their community in which they live. Second guessing these duly elected local prosecutors undermines local control and erodes community self-governance. Spreading out the prosecution function among DAs in each county avoids a concentration of too much power in one centralized entity. Here's the facts. DAs have always had tremendous discretion throughout our history to prosecute or decline to prosecute cases, and they regularly exercise discretion in classes of cases, from bail to sentencing requests to old, outdated laws that are on our books but routinely not prosecuted now, such as crimes against adultery. Efforts to undermine their discretion or push that discretion into the shadows, even worse, deprives voters of the opportunity to hold prosecutors accountable for their policies by their voters, the ones that they are responsive to and the ones that have sent them to their seat. In a world of very limited public resources, something that all of us understand here in this chamber, district attorneys simply cannot prosecute every single crime and petty offense that occurs within their jurisdiction. They must make decisions on how to use their precious resources within the permissive borders of deliberately broad and plentiful criminal laws. They serve as ministers of justice and are actually ethically bound to pursue those interests already. The ABA rules make clear that it is the responsibility of a prosecutor not to serve just as a zealous advocate, but to quote unquote, do justice, quote, do justice, unquote, on behalf of the people. The onus is on these duly elected district attorneys to promote public safety in the communities that they serve. That is not a one-size-fits-all across the whole state. And there actually is substantial evidence that in many instances, some of the more punitive and overweening approaches to criminal justice actually end up undermining public safety as they undermine community trust. Thank you, Mr. President. Just wanted to lay out some of the points again about the overthrow of district attorneys in this state being able to serve the people that elected them. And I'm happy to answer any questions, and if not, I will request a no vote and yield the well.
You do have a question, Senator.
Okay.
Senator from the 37th.
Thank you, Mr. President. Does the lady yield?
Of course.
Isn't it true that we elect our Superior Court judges here in the state?
It is true.
Isn't it true that the actions of Superior Court judges are subject to the voters as well? As
They
DAs?
are. They are.
Isn't it true that we have a Judicial Qualifications Commission that's been in place in Georgia since 1972?
That is true, but there's a key difference, Senator.
Would you advocate the repeal of the JQC?
What I would advocate is that all prosecutors in the state fall under this new body, and in this legislation, they do not, which is a key difference with the Judicial Qualifications Council. Moreover, not all judges are attorneys, but all district attorneys are attorneys, and then therefore they are beholden to the State Bar of Georgia and all of its rules, as well as the American Bar Association, and the same cannot be said of all judges in the state of Georgia.
Isn't it true that all Superior Court judges in the state of Georgia are attorneys and they're members of the bar?
They are, but that particular body that you brought up oversees more than Superior Court judges.
Okay, having made that point, I want to get back to Superior Court judges. The point is, we've got a process in Georgia, isn't it true, to deal, have oversight of our judges who have a role that's at least as important as DAs. I think it's high time, isn't it true, that we have a similar organization, that even though DAs are locally elected, there's still professional accountability across the state. Thank you.
Senator, I think that you make a great point, and that's why I think it would have been wiser to not create a constitutional class with certain constitutional issues that arise in this bill, treating different prosecutors differently by exempting certain classes of prosecutors in our state from this new oversight commission in a way that is not done in the Judicial Oversight Commission. And I agree with you that it would have been smarter to take that approach, and then we could say that it was applied equitably, which again would avoid some of the constitutional problems with this particular piece of legislation. Thank you, Mr. President. I yield the well.
Thank you, Senator. Senators, yield to the well. Does any other senator wish to speak for or against the measure? Hearing none. So the posture we're in is that the Senate has agreed to the House substitute on Senate Bill 92. Is there objection? Is there objection? You object? Okay. All right. So now that those in favor of the motion will vote yea. Those opposed, nay. Secretary, unlock the machines. On the passage of the bill, the yeas are 32, the nays are 24, and this bill has prevailed. All right, we're getting close, y'all. We're getting close. I recognize the senator from the 54th for a motion.
Mr. President, I move that the Senate insist on its amendment to House Bill 142.
Senate has insisted on its position on House Bill 142. Secretary, read the caption.
House Bill 142, a bill to be entitled an act to amend Chapter 8 of Title 20 of the Official Code of Georgia annotated, relating to campus policemen, so as to provide for the establishment of unified campus police forces through agreements entered into by colleges and universities. The Senate offered the following amendment to amend House Bill 142 by striking 500 on line 16 and replacing with 200, by striking 1/4 on line 17 and replacing with 1/10. That completes the order, Mr. President.
Senator from, I recognize Senator from the 54 to speak to the motion.
Thank you, Mr. President. My friends, if you'll remember, we passed this by a unanimous vote in this chamber with a small change, and all this bill does is it creates the unified police force for Spelman College, Clark Atlanta, Morris Brown, and Morehouse College. We overwhelmingly passed this, but with a small amount amendment. And the purpose of that amendment was to make sure that we're protecting students. We don't need to be running radar out on the city streets, but we need to make sure that when these kids are on campus that they're being looked at. So we brought it in that to 200 yards outside of the campus, the police are allowed to patrol, but to keep them constrained to the campuses. So therefore, they will keep our students straight. Mr. President, if there are any questions, I will yield the well.
Questions, Senator.
I ask for your favorable support.
The Senate stands strongly behind you, Senator. Senator has insisted on his position to House Bill 142. Is there, without objection, we're going to send it back to the House here. Without objection, the position is stated. Recognize the Majority Leader for a motion.
Thank you, Mr. President, and I ask for unanimous consent that we suspend Senate Rule 2-4.9, Paragraph A, so that those bills laid on the table before today will be available to consider on day 40.
The Majority Leader has moved that according to that we suspend the rules 2-4.9 so that the bills that we laid on the table for today can still be considered for tomorrow. Is there objection to that? Wednesday for day 40. For day 40, Wednesday. So, if there's no objection, then your motion has passed, Senator. The Majority Leader wants to work till midnight. Y'all ready to go home? I recognize the Majority Leader for a motion.
Thank you, Mr. President. I move that the Senate stand adjourned pursuant to SR 6 until 10 a.m. Wednesday, March 29th, which will be day 40.
All right, the Majority Leader has moved. Secretary, read the announcements. We have no announcements. The Majority Leader has moved that we stand adjourned until Wednesday, 10 a.m., March 29th, which will be day 40. All those in favor of the motion will signify by saying aye. All those opposed? No. The ayes clearly have it. We're adjourned.